Good afternoon, Makhija sir.
Good afternoon.
Sir, I think people are joining, participants are joining. So should we wait for 5 more minutes?
Yeah, as you wish. I mean, I'm there.
Sir, let's wait for 5 more minutes so that other participants, there are almost 60 to 70 participants who are joining the series.
Okay. I think we can wait for 5 minutes, but I think we must start in time. So those who don't join, let them be at loss.
Okay, sir. Okay, sir. Then if you say, we will start. Sir.
No, 5 more minutes, not a problem.
Okay. I think we should start now, sir.
Yes, please go ahead.
Yes, sir. So, very good afternoon and warm welcome to all of you. On behalf of ICSI IFB, I would like to thank all our participants for participating over this online IBC series and becoming a part of interactions which are being organized from 16th January to 20th January. I would also like to extend thanks to all our eminent speakers for kindly agreeing to deliberate in this series on the most interesting theme, insolvency law in the year 2022, lessons and way forward. We are too eager to know from our speakers as to how have been the year 2022 in terms of IBC law, what should be the technicalities to look after in terms of legislative process and as per the judicial pronouncement, and what are the lessons and way forward in IBC for the year 2023. Today we are having our third session of the series on the most interesting topic, landmark decisions rendered by Supreme Court in the year 2022. In the year 2022, several noteworthy judgments have been rendered by Supreme Court in the matters pertaining to insolvency and bankruptcy code. For enlightening our participants on this topic, we have requested Ashish Makhija sir. I believe most of the professionals already know Ashish Makhija sir, but still, let me give you a brief introduction of sir Ashish Makhija sir. Sir is a managing attorney of AMC law firm. He's a chartered accountant, cost accountant, and an advocate. He has over 33 years of hands-on experience in commercial and corporate and allied laws. Uh, he also holds master's degree in law from India and USA as well. He's a professor at IICA, Indian Institute of Corporate Affairs. He has been a professor at Thomas Jefferson School of Law, San Diego, USA. He has published several books and research papers to his credit. Sir has been our regular faculty in our webinars, workshop, and other programs. Now I request Ashish Makhija sir to kindly take the session.
Thank you, Peer, for such a generous introduction. Thank you so much for inviting me. I think it is always a delight to be a part of ICSI IIP, because I think you are at the forefront of holding such wonderful programs for updation of the members. I think all of us travel in the same boat, that everyone, each one of us have to be updated. So friends, first of all, a very good afternoon to all of you. I think I'm also extremely delighted to see all my friends here, all my fraternity colleagues. I can only request one thing, friends. And my request, probably most of you know. Please open your videos if possible, because I don't want to speak to blank screens. I think it is always good that if we are able to interact in a better manner if everyone opens their videos. And we can also see the background settings of your offices where you are sitting. I think that is wonderful. Okay, and the second aspect is, friends, insofar as the discussion is concerned, because today what I'm going to discuss is the judgments of 2022. Well, in fact, the topic is landmark judgments. According to me, every judgment is a landmark judgment, isn't it? And I can see Anjali Sharma ji also. I will also be covering one of her judgments. And we will also ask her. So all what I'm saying is that if you have been involved in that particular case, so please come out and give us the proper facts so that everyone understands what were the facts of the case at that particular time and what was the argument which took place before the bench, so that we'll get an idea. Of course, the jurisprudence we can read by reading a ratio and other things, but insights are always given by the person who are involved in it. So I think, friends, let's start in the right earnest, because and some judgments, of course, okay, the another thing is, I'm not going date wise of the judgment. I'm not going the importance wise also. I have prepared you see, a PPT of around 113 slides, which I don't know whether I'll be able to cover in 3 hours or not, but these slides will be with you. And also what I've done is that all the judgments which I've covered in my PPT, which are numbering around, I think, 26 or 27, we have created a PDF file also, which runs into 1100 pages, right? All the judgments at one place. So I will also hand it over. I'll send it to Peer. I think she will be able to circulate to all the members for your benefit. So you don't have to search anywhere. You will get the judgment with the index, which is prepared there with the page number. So I think everything has been done for you. Only thing is you'll have to read. That's all. Okay. Okay. So let me start. And if you have any question after every every case, we can have a small debate and discussion also. But at the end of the day, my purpose would be to cover all, judgment, so that we are in a better footing. Okay, now let me start sharing it. Okay, unfortunately, why I can't share? Yeah, okay, it is there. Okay, let me increase the size. Yeah, I believe I'm able to share it. Peer, are you able to see that?
No, sir. It's not visible.
Okay. It says your screen is paused, resume share. I'm just trying to click that, but I'm not able to do that. I don't know what is the problem.
Sir, at the bottom, you are using that option, share screen.
Yeah, I'm doing that. And it says, okay, just let me stop share and do it again. Let me see. Okay. Again, I believe it is. I'm just getting a message. Your screen sharing is paused. I don't know why it is saying so. Okay.
See, my screen says Ashish Makhija has started screen sharing, but it's blank.
Correct. Mine is saying there is a button which is coming as resume share, but it is not coming. Okay. Peter, let me do one thing. I'll just, you see, log out and log in again. Maybe sometimes you see that solves the problem. Just give me 2 minutes. I'll come back again.
Sure, sure.
Okay, friends, I am back. Let me see if I can do it now. Yeah, is it okay now?
Yes, sir.
Yes, it's okay, sir.
No, we can see.
Yes, it is now visible.
No, it is visible.
It's visible now.
It is visible.
Okay,
Now
great.
you can see.
Great, thank you. So now let us go to the first judgment, which is very important judgment for all of us. And that was Vidarbha Industries versus Axis Bank, which was rendered by this Honorable Supreme Court on 12th July 2022. Now, friends, let us try to understand what are the facts of this case particularly. Now, in this case, what had happened, the NCLT and the Appellate Tribunal, NCLAT, now they have actually proceeded on the premises that an application has to be admitted under Section 75A of the IBC if the corporate debtor commits a default. And of course, here the question of pre-existing dispute does not arise. So therefore, they considered that provisions of 75A are mandatory. And this jurisprudence is not new jurisprudence. Friends, I think we are aware that the first judgment of IBC, which was Innovative Industries versus ICICI Bank, now that also gave a direction. It was not on this point, but ultimately, while dealing with the IBC provisions, the bench also examined the provisions of Section 7, 5, 9, 7, 8, and other provisions, and they concluded that these are the things which the adjudicating authority has to see. Number one, if there is a default, whether the default has been committed or not. Two, whether that default crosses that threshold limit. And at that time, the threshold limit was 1 lakh. Now, of course, it is 1 CR. So these are the two things which they had to see, because here, in case of a financial creditors, the question of the pre-existing dispute does not arise. But in case of operational creditor, then in the second judgment of the Honorable Supreme Court, Mobilox, I think everyone is aware about Mobilox judgment, where what the adjudicating authority has to see under Section 9, which included that, whether there is a pre-existing dispute or not, that is also an aspect which must be seen. So those are the three things. And of course, under Section 75A, it also says whether the RP, which is to be appointed, IRP, whether any disciplinary proceedings are pending or not. But otherwise, not only the NCLT or NCLAT, all of us have been under the impression that if there is a default, and two, it crosses the threshold limit of us, you see, the financial creditors, then the application has to be admitted. It cannot be rejected. We were also under the same impression. So going by that impression, NCLT and NCLAT also accepted that. So now, but what happened is, the question now before the Supreme Court was whether the provisions of Section 75A is mandatory or discretionary or directory. Now, friends, if we look, before I go further, let us look at the provisions of Section 75A. What does 75A say? 75A, if you look at very carefully at the words, it uses the word may. Let me read it for your benefit. I think then we will be on the same page. 75A says, where the adjudicating authority is satisfied, a default has occurred, and the application which is made under subsection 2 is complete. So two things they have to see. Complete means crossing the threshold limit and there is no all the columns have been filled in. and there is no disciplinary proceedings against the proposed resolution professional, it may, the word is may, by order admit such application, or in case these things are not satisfied, it may by order reject. So now the question was before the Supreme Court that whether this may makes the provision or it gives the power to the adjudicating authority as a discretionary power to reject also. Supposing I come with a plea that I am a solvent company, I am a viable company, I have got a positive net worth. Can I take those grounds? We have been under the impression all throughout, friends, and I think there have been a lot of cases in this, that this aspect is not considered. Whether I am viable, whether I am solvent, whether I have positive net worth, whether I'm a going concern, whether I'm an MSME, these factors really did not matter at the time of admission of application under Section 7. But now this question came, and this was looked at from a different point of view altogether. Now, what the Supreme Court said in this Vidarbha judgment? Vidarbha judgment, the Supreme Court said the legislature has used the word may in 7.5a. And they compared this and look at in a contradistinction with Section 9.5a, where the word shall has been used. So therefore, the Supreme Court says that both the provisions, they are intended to convey a different meaning altogether, because use of the word may and shall. So obviously, and they say that it is apparent that the legislature intended 9.5a to be mandatory and 7.5a to be discretionary. So they have played on the language of the section 7.5a and 9.5a. So you can compare both of them. And of course, you see, while dealing with the, what you call it as operational creditors, now what they did, they have actually gone in a little elaborate position. They say an application of an operational creditor for initiation of CIRP under Section 9.2 is mandatorily required to be admitted if the application is complete and in compliance of the requisites of rules, IBC and the rules which have been framed thereunder. Number two, there is no payment of unpaid debt, notices for payment have been delivered, and no notice of dispute has been received. And the last sentence is very important, friends. The Supreme Court says IBC does not countenance dishonesty or deliberate failure to repay the dues of an operational creditor. So this is only in respect of the operational creditors. They say you can't be dishonest. If you being dishonest, then of course the application has to be admitted. So this is what they are saying. On the other hand, now they are comparing it that in case of an application by an FC, who might even initiate proceedings in a representative capacity on behalf of all FCs. Now here, this is very important sentence. The adjudicating authority might examine the expedience of initiation of CIRP. Now, what do you mean by that? Taking into account all relevant facts and circumstances, including the overall financial health and viability of the corporate debtor. So it was a major shift, my dear friends, from innovative, which was given as a landmark standard. Now here, there is a complete, you see, 180 degree, you can say maybe 360 degree turn by the Supreme Court by saying that, look, the adjudicating authority can look into the relevant facts of circumstances, including the viability, including the financial health. So this is extremely important. The adjudicating authority may, in its discretion, not admit the application of a financial creditor. So this is exactly the ratio of this particular judgment. Now, in fact, they have given certain this thing. The adjudicating authority, now what happened in this case? In this case, the corporate debtor argued that, look, my lords, I have got a certain decree in my favor. When a decree is passed, obviously the money has to come to the CD. It may not come today, but of course we have to file for the execution. So if there is an award in favor or a decree in favor, he says this is a relevant fact which the adjudicating authority must consider. This is exactly what is they have mentioned. Adjudicating authority has to consider the grounds made out by the CD against admission on its own merits. For example, then they have given an example as an illustration only. When admission is opposed on the ground of an existence of an award or a decree in favor of the CD, and the awarded decretal amount exceeds the amount of the debt, the adjudicating authority would have to exercise its discretion under Section 7.5a to keep the admission of the application in abeyance unless there is a good reason not to do so. The adjudicating authority may, for example, admit the application notwithstanding any award or decree if award or decretal amount is incapable of realization. The example is only illustrative. So this is one instance where they say that, look, if you have got an award or a decree in your favor, the corporate debtor can come out and say, look, the amount of the award is more than the debts which are there. So therefore, please do not admit the CIRP for the time being. And exactly this was done in this particular case. So here, friends, I'm being very crisp and short. The Supreme Court said they rejected the application saying that, look, the corporate debtor has got award in its favor, decretal amount in its favor, which is more than the amount of the debt on the basis of which the CIRP is being started. So they said, you have to use your discretion and you must use your discretion. So now it changed the whole jurisprudence and it gave powers that you may or may not admit it, depending upon what factors you are able to convince, you get convinced. Supposing if the corporate debtor comes out with some credible arguments on this particular thing, on the viability, on the soundness, on the liquidity, or on the positive net worth, and as a going concern, a lot of employees are working. So there can be a number of instances which you can argue. In fact, after this, we have also argued before NCLT benches on these grounds. And what happened in one of the cases, and I must tell you, you see one more aspect. In one of the cases, before the NCLAT, this point was argued and on the basis of Vidarbha. And NCLAT said that, look, the company is viable, the company is solvent, the company has positive net worth, so therefore we have a discretion, because if NCLT has got a discretion, even NCLAT has got a discretion, because appeal is a continuation of the original proceedings. So they also said CIRP should not be started. They rejected they set aside the order of the NCLT. Now, what happened to that case, I'll come to in a little while, but let us look at what happened, because this judgment, a review petition was filed against this judgment. So a review petition was decided in September 2022. So original judgment was in July, and which happened in review. And what happened in review? Let us understand that. The review was dismissed by the same court. On what? They say there is no ground for review. There was an apprehension which was mentioned by the Solicitor General, by the SG, saying that this judgment will undermine the objectives of the IBC. They said, sorry, this is an apprehension which is completely misconceived. And observations are made in the context of the case at hand. And they also clarify in a little bit manner that the judgments on observation in judgments are not to be read as provisions of the statute. Judicial utterances and or pronouncements are in the setting of the facts of a peculiar case. So on the one hand, the judges are rejecting the review, dismissing the review. That means their judgment stands. But they, on the other hand, they are giving a small clarification that, oh, we gave that judgment in the settings of that case, in the facts and circumstances of that case. So therefore, based on the review petition judgment, one can always argue, the opposite party can always argue that my facts are different from Vidarbha, so therefore Vidarbha judgment does not apply to me. So this is one argument which one can take. But at the end of the day, nobody really talks about the review petition, but everyone talks about the ratio which is given in the main judgment. Now, friends, let us go fast forward. I am showing you a Supreme Court order which happened yesterday itself, on 16th of, a day before, sorry. It happened on 16th. This is the case. Magan Lal Daga versus Jagmohan Daga and others. This is an appeal number because there is no citation right now. It is an interim order. 38798 of 2022 before the Supreme Court, and the date is 16th January 2023, just 2 days back. So I got this order yesterday. So therefore, I'm just producing it. Now, what happened in this case? Let's try to look at what happened. Here, NCLAT actually had relied on Vidarbha judgment and did not start the CIRP. Right? So this was a case which I was mentioning where the NCLAT gave a judgment where they relied upon Vidarbha. They say we can look at those factors, and looking at those factors, the company is solvent. So therefore, CIRP should not be started. Now here again, the same SG appears and he says, makes the same argument which he made before the review court. He says, decision in Vidarbha runs contrary to the settled position of law in innovative case. So now they are mentioning about innovative. And secondly, they say principle established in Vidarbha is likely to dilute the substratum of the IBC. Same argument which was taken before the review court. And here it was before the Chief Justice Court, 3-member bench. Our CJI Justice Chandrachud, he has issued notice on this particular appeal, and they say, yes, there are certain grounds. We are issuing notice, which is now returnable on 16 February 2023. So we don't know what is going to happen as far as the fate of Vidarbha is concerned. Most likely, it seems that the Supreme Court is willing to reconsider. It is in the light of innovative. So now we know that there is one more judgment may come, and in fact, this is a 3-bench judgment. So 3-bench judgment will be binding on everyone then. So I think this position is, supposing now somebody argues on Vidarbha, you can show this judgment, this interim order now, saying that this matter is now before the Honorable Supreme Court. So of course, Vidarbha has attained finality after the review petition, but still, if you show this, probably NCLT will wait for the judgment in this particular matter. Okay. So, and this matter, I can again show you the name if you just want to note down. Of course, these slides will be with you. Magalal Daga versus Jagmohan Daga, appeal number 38798 of 2022 before the Supreme Court, civil appeal number. Okay. So this was, I wanted to just brush you about the latest in Vidarbha's matter. So friends, any thing you want to discuss on this, or you also faced any problem like Vidarbha or something, or you argued? Anyone who wants to contribute, or otherwise I'll move forward. Because you're free to open your mics and let's have a discussion if you wish to have it. Okay. So it seems I can move forward. Okay, let's look at another judgment, which is Ashok G. Rajani versus Beacon Trusteeship. And I've given a citation also, friends. This is AIR 2022, Supreme Court 4863, and it is dated 22nd September 2022. Now, this is a very short kind of a, so I'll give you straight away the ratio rather than giving you the facts and other things, because it's a very short thing. In fact, the question was whether before the constitution of the COC, whether the settlement can be entered or not. NCLAT actually refused. NCLAT said that, look, I cannot entertain because there are certain claims which are against the corporate debtor from the third parties. There might be certain claims. Because what happens? Once a CIRP starts, within 3 days, the IRP has to make a public announcement, and then within 14 days, the claims come. Now, supposing the CIRP has been started by one creditor, but now say 200 creditors file the claim, and their claims basis will be very large, maybe say 20 crores, 30 crores, whatever amount can be there. So now the question that arises is, now at this stage, supposing right now the COC has not been constituted because the claims have not been verified. Now the promoters, they settle with the particular creditor who has started this. So can the bench, NCLT bench or NCLAT bench, what should they do? Whether they should allow withdrawal or whether they should not allow withdrawal, or they should allow the COC to be formed and then 90% of the COC should be, looking into it. But anyhow, we are very clear in our regulation also, friends. Even our regulations also very clearly mention that before the constitution of the COC, even withdrawal can still be allowed. Here, there is a specific judgment of the Supreme Court. It says, a settlement cannot be stifled before the constitution of the COC in anticipation of the claims against the corporate debtors. And they have actually looked at Rule 11, and they say, in fact, friends, Rule 11 of NCLT rules and Rule 11 of NCLAT rules is absolutely the same. It is ditto. There is no change in the word, which talks about the inherent powers of the NCLT or NCLAT. This is absolutely same. And in fact, this is also mere coincidence that in both the rules, it is rule number 11. So rule 11 of NCLT rules enables the NCLT to pass orders for meeting the ends of justice, including order permitting an applicant for CIRP to withdraw its application and to enable the corporate body to carry on its business with ease, free of any impediment. So now rule 11 has been expanded to include the power of the NCLT or NCLAT to allow withdrawal even before the constitution of the COC. Well, whether this was an objective of the amendment of section by bringing in 12A or not, that apart, here the Supreme Court's judgment is binding on all of us, and this gives us a clear power. So if you are handling such a case where you can say you are appearing on behalf of the promoters of the corporate debtor or the CD, and you have entered into a settlement even after the CIRP is over, then in that case you can always convince the bench by saying Rule 11, now quoting this particular case, that look, here is a Supreme Court judgment. So I think we are very clear on this, that these NCLTs and NCLATs can do that. Now, friends, this third judgment is slightly based on the facts of the case. I'll tell you, but it's a very interesting case. It is Matre Doshi versus Anand Rathi Global Finance Limited. This is AIR 2022, Supreme Court 4595, and again 22nd September 2022. Let us try to understand the facts of the case. In this case, I think most of you know about the Premier Limited, which used to manufacture Fiat cars. Now, Mr. Matre Doshi was actually the promoter of that company, Premier Limited. Now, of course, the name is Premier Limited. Earlier, it was Premier Automobiles Limited, PAL, it was the name, but now it is Premier Limited. Now, Premier Limited came into CIRP, right? So Anand Rathi Global Finance Limited had given some loans to Premier Limited. But what they did, they actually, took certain shares from one of its holding company, Doshi Holdings Limited. Now there is another company by the name Doshi Holdings Limited. Now Doshi Holdings Limited had pledged its shares for the debts of the corporate debtor. Now that's an interesting this thing. So now the question that arises is whether the person who has pledged, that is the pledgor, can CIRP be started against the pledgor? Now that is also very important. So let us read the small facts of this case once again. NCLT Mumbai admitted the petition under Section 7, which was filed by Anand Rathi for initiation of the CIRP of Doshi Holdings Private Limited. This particular Anand Rathi had disbursed a loan of 6 crores to Premier Limited. So loan was not given to Doshi Holdings, it was given to its group company or whatever company, Premier Limited, and under 3 loan cum pledge agreements. Doshi Holdings pledged shares held by it in Premier in favor of the financial creditor by way of a security of a loan. Now the appellate authority, they dismissed the appeal which was filed by Doshi Holding because NCLT started it, appeal was filed and appeal was dismissed. They said, sorry, we can start. So naturally, the promoter of Doshi Holdings, which is Matre Doshi, he also went to Supreme Court, right? So the findings of the appellate authority, now this is the ratio of the Supreme Court. Supreme Court is relying upon one of the interesting factual position, friends. So let's not treat that it can be started against a pledgor or not. It's not a question which has been decided here. The facts are little different. Now, what are the facts? The finding of the appellate authority that Doshi Holdings is a borrower is based on the interpretation of the loan cum pledge agreements and supporting documents. Now, what happened in the facts of the case? The loan cum pledge agreement, which was signed by Doshi Holdings, in that Doshi Holding was categorized as a co-borrower. Now, that is the fact which twists the whole thing. So let's understand the facts of this case. So it was considered as a co-borrower. So the NCLAT came to the conclusion that, look, you have been designated as a pledgor as well as a co-borrower. So if you are a co-borrower, then sorry, you are covered under this thing, and the proceedings can be started against you. Had you given only pledge of the shares, probably the situation would have been different, because what happens in a pledge? Supposing I pledge certain things, you can take possession of the pledged items and you can sell them and recover the money. Then my liability is not there beyond the pledged documents or pledged assets, isn't it? So here, the interpretation given by, now here what the Supreme Court says. Supreme Court, they were asked to look at it, though they have arrived at a wrong conclusion. The Supreme Court refused to enter into that. They said, interpretation given by the appellate authority is a possible interpretation. In our view, interpretation is a plausible interpretation which cannot be interfered within an appeal under Section 62 of IBC. So what do we learn from here, friends? That on the basis of the facts of the case, if NCLAT comes to a particular conclusion that this is the situation, Supreme Court will never interfere with that. Supreme Court will say, okay, come on a question of law. We are not entering ourselves into a question of fact. Because if you look at Section 62 very clearly, it says appeal lies before the Supreme Court only on question of law, not on facts. So this is the learning or the takeaway from this judgment. So you can always argue. If you are arguing before Supreme Court, you can always argue on these lines. The proposition of law which emerges from the judgment is that a pledger per se may not be a financial creditor. So please understand this, friends. A pledger per se is not a financial creditor. But however, in this case, as observed by above, the appellate authority arrived at actual finding that Doshi Holdings was a borrower. So because they were considered as borrowers, then it was there. Now the question, second question. If there are two borrowers, right? Now, whether the proceedings can be initiated against both the co-borrowers, the answer which has been given by the Supreme Court is yes. They say if there are two borrowers or if two corporate bodies fall within the ambit of the CD, there is no reason why proceedings under Section 7 cannot be initiated against both the corporate debtors. But then they have also added a word of caution. Needless to mention that the same amount cannot be realized from both the corporate debtors because the underlying amount is same. Supposing I have taken a loan of 6 crores. So 6 crores I have to recover from the main CD to whom I have given the loan. 6 crores I have to recover from a co-borrower. Now, supposing I am able to recover in a CIRP, say 4 crores. Now, I cannot claim that 4 crores from the other CD. I will only claim 2 crores. So this is what they are clarified. If the dues are realized in part from one CD, the balance may be realized from the other CD being the co-borrower. However, once the claim of the FC is discharged, there can be no question of recovery of the claim twice over. Obviously, that is but natural. You can't recover your amount. There can't be unjust enrichment on anything. So this is a very interesting judgment, friends, on the pledger vis-a-vis the borrower. So please look at the documents. Now, what is the takeaway? The takeaway is, supposing if I'm a corporate debtor today and I'm the pledger only, I must look at my documents very carefully. If I'm designated as a co-borrower, then I'm in trouble. If I'm designated only as a pledger, then I'm not in trouble. So therefore, while drafting the agreements also, I think one has to be extremely careful, isn't it? So this was another interesting judgment on this particular aspect. Okay. Now, friends, let's move on to the next one. K. Parmasivam versus Karur Vyas Bank, All India Reporter 2022, Supreme Court 44127. It is 6 September 2022. Friends, September 2022 was a month in which a lot of judgments came of Supreme Court on IBC. So I think we saw most of the judgments in September. Okay. So let's look at the judgment. Now, here is the issue. It's a very small issue. So whether CIRP can be initiated against the corporate guarantor without proceeding against the principal borrower. I think the answer is very simple and most of us know it, but let me explain it in a little bit. Those who are not aware about who is the principal borrower, who is the guarantor. Supposing X is a principal borrower and Y Limited is a corporate guarantor and say Z is a personal guarantor. Right? So these corporate guarantor as well as personal guarantor have given a guarantee for the securing the debts of the corporate debtor X. Now the question that is that supposing X fails to pay, there is a default. Naturally, the bank can proceed against X, but supposing the bank does not proceed against X, and it also simultaneously invokes the guarantee, corporate guarantee given by Y Limited. And also invokes personal guarantee of Z, personal guarantee, right? I'm saying individual. Now, the question that arises is that without starting the CIRP proceedings against the principal borrower, which is X Limited, can I straight away start the CIRP against the corporate guarantor because I have invoked the guarantee and there is a default? You have not paid it. Or similarly, then a second question can also come. Can I start personal guarantee proceedings against the personal guarantor Z without starting the proceedings of CIRP against the principal borrower? The answer which has been given by Supreme Court, I think most of you would be knowing the answer is yes. Because it is very simple, friends, that it is the prerogative of the financial creditor or the lender who has given the money, whether they want to recover the money from principal borrower or the guarantor. It is their choice. So it is not, because we have always been under the impression, oh, you have not proceeded against the principal borrower, you can't come against me. Pehle aap usse recover karo. But that is not the case, right? Because as far as the liability of the surety, which is a guarantor, is coextensive with that of the principal borrower, Indian Contract Act is very, very clear on this aspect. So under Section 7 of IBC, this is what Supreme Court says. CIRP can be initiated against a corporate entity who has given guarantee to secure the dues of the non-corporate entity as a financial debt accrues to the corporate person in respect of a guarantee given by it once the borrower commits default and the guarantor is then the corporate debtor. In fact, this is another interesting case. Supposing loan has been given to a society, which is a school, and corporate guarantee has been given by a corporate debtor, one company. Obviously, CIRP cannot be started against a society, right, which is a school or a trust. But now here, being a corporate guarantor, if the guarantee is invoked, not paid, then proceeding CIRP can be started against the corporate debtor. Okay. So issue, and of course, they have also referred to Lakshmipad Surana. I believe everyone knows about Lakshmipad Surana judgment. And they have also relied upon Lakshmipad Surana, which was rendered by a 3-judge bench of Honorable Supreme Court. And they say it was open for the financial creditors to proceed against the guarantor without first suing the principal borrower. So I think this is a very simple principle. I think most of us are aware of this. Now, friends, this is a very, very interesting judgment. Sundaresh Bhatt, who was a liquidator of ABG Shipyard versus Central Board of Indirect Taxes and Customs, because this is a case which is a fight between Customs Act and IBC, right? I did not get any SEC citation, so I'm giving you a different citation scale citation here. I was not able to find out AIR or SEC citation, but it is 2022, volume 13, scale 275, 26th August 2022. Now, let us look at the facts of the case first. Here, the Supreme Court was actually considering an appeal, obviously, an appeal against the NCLAT order, in which NCLAT has held that the goods lying in the customs bonded warehouse were not the corporate debtors' assets. Now, what had happened? Company had imported certain goods, custom duty not paid. So obviously they were in custom bonded warehouse. Till the time you pay duty, customs will not release that. So therefore, it was kept by them. So now the question that arose was whether the goods which are lying in customs bonded warehouse, right? If I have not cleared those goods, whether those goods can be taken possession by the RP, whether he or she can take the custody and control of the asset, because the fact of the matter is that the person has to take control of all the assets. So this was an issue where NCLAT said that these are not the assets of the corporate debtor. Because A, you never claimed, B, and you did not clear the bill of entry. That means you did not pay the customs duty. Now, the question before the Supreme Court was this: whether the provisions of IBC would prevail over the Customs Act, and if so, to what extent. So now there is a clash, my dear friends, between Customs Act and IBC. And number two, the second question which is related to this is whether the respondent, which is a customs authority, can they claim title over the goods and issue notice to sell the goods in terms of Customs Act when the liquidation proceedings have been initiated. Now, this is an interesting case. So two things: which act prevails over the other, and then the second question is whether the customs, under the Customs Act, obviously the custom authorities have got a power to sell the goods. If you are not claiming it, so after a certain while, they can issue notice and then they can sell the goods. But there the question was, when the liquidation process has been initiated, so whether they can sell it or not. Now here, the Supreme Court said that number one, IBC would prevail over the Customs Act, to the extent that once the moratorium is imposed in terms of section 14 or 33(5) of the IBC, so they are considering both the situations, CIRP as well as liquidation. Because my friends are aware that moratorium under CIRP is covered under section 14 and moratorium under liquidation is covered under 33 subsection 5. The respondent authority only has a limited jurisdiction to assess, determine the quantum of the custom duty and other levies. He says, fine, you want to assess, you want to determine the duties, you do that. But you do not have the power to initiate recovery of the dues, because recovery is barred. If you look at section 14, it is very clearly says that recovery is barred. And in fact, recovery is nothing but a legal proceeding also, isn't it? By means of a sale or confiscation as provided under the Customs Act. So once they have decided that IBC overrides the Customs Act, obviously the provisions of IBC will take precedent over this. So they say that they have a limited jurisdiction to assess. They cannot initiate recovery. And after such assessment, now they have also gone ahead, one step ahead, that after such assessment, supposing some amount is to be recovered from the corporate debtor, they said, please submit your claim. So whatever your custom dues, you must file it as an operational creditor or in terms of the procedure laid down, and whatever the timelines are there, you must do that. So in any case, now what they have given the power to the IRP or RP or liquidator, both the situations are covered. In any case, IRP, RP or liquidator can immediately secure the goods from the respondent authority to be dealt with appropriately in terms of IBC. So friends, in case you are faced with a situation where the goods are lying in Customs Department based on the moratorium, they cannot recover, they cannot initiate recovery. And if the company comes into liquidation, then obviously the liquidator has to secure those goods and they will have to sell it and will have to pay in accordance with the waterfall mechanism under section 53, provided of course the customs file the claim. So if they don't file the claim, it is up to them. So this is also a very good case where as far as the customs authorities and other things are there. Now, but there is a one slight fact of this. And friends, this judgment was given by, you can say, the previous Chief Justice, the immediately retired Chief Justice, Justice Ramanna. In fact, this judgment was given by him on the last day when he was laying down his office. So it was rendered in the last day or maybe one day before. Now, what he has mentioned, now this fact is very interesting. They say the fact is that duty demand notice, because a demand notice for duty and a notice under 72 of the Customs Act were issued during moratorium period. Now, which has been completely ignored by NCLAT and has resulted in rendering the moratorium OTOs. They say the notices or the demand notice was issued by the customs authorities during moratorium period. So what the Supreme Court is saying, number one, during moratorium, even a notice under section 72(2) of the Customs Act cannot be issued, number one. Number two, it does not deal with a situation, supposing this notice was issued prior to CIRP, then what happens? Right? So that is also, supposing they had already taken the custody under 72(2). Now, but the thing is, can they sell it? The answer again remains no, because they cannot sell it, because it is an asset of the corporate debtor. So anyhow, but that situation is not dealt in herewith because the facts are a little different. The interpretation provided by NCLAT regarding the deemed transfer of title of the goods from SSC to Customs Authority under section 72 would fly in the face of section 14 of the IBC read with section 25 and 33(5). Because in 25, there is an obligation on the part of the RP to take in control and custody of the assets of the corporate debtor. So they say it will fly in the face of 14 and 25 and 33(5). But friends, one thing we have to bear in mind that here the notice was issued during the moratorium period. Now, it is not dealing with a situation where you see a notice was issued prior to the moratorium period. So it does not deal with that situation. So anyhow, for that probably will require another judgment on this or for the Supreme Court to come out with. But anyhow, these are the facts of the case. Okay. Friends, I'll just stop here in case you have any questions or any comments to make or any feedback or any suggestions. I think we can discuss it. Okay. It looks like there are no more questions. Let me look at the chat box. Peer, are there any questions in the chat box?
Hello.
No? Okay.
Hello, sir.
Yes, sir.
Hello.
Yeah, please go ahead, sir.
Hello.
Yes, so we can hear you, sir. Please identify yourself.
Is there a relevance to RR Act and IBC? Proceedings initiated against RR Act.
Which act, sir?
Revenue Recovery Act, sir.
Revenue Recovery Act. Okay.
Yeah.
I think, sir, I'm not really aware of what is Revenue Recovery Act. Can you just explain what is that act?
Pardon?
Can you explain what is that act, sir?
Revenue recovery in the case of defaulters in the loan, bank loans.
Okay.
If the loan pending is there, then we will initiate RR revenue recovery proceedings through district collector. And property will be prosecuted and it will be under the control of the district collector and it will be handed over to the financial institution. That is RR Act. So that if proceedings are initiated against RR,
Right.
can we apply the IBC?
Okay, see, there are two things. Let us try to understand. Number one, if the CIRP has already started, then neither action can be taken against Revenue Recovery Act or SURFACE, whatever act may be there, because that recovery is barred, sir. I think Section 14 is very, very clear in all its terms, right? Now, if the company is not under CIRP, supposing Revenue Recovery Act, some action has been initiated. Supposing they have taken custody of the property, some receiver has been appointed, but the property has not been sold so far.
Yeah.
So then during CIRP, it cannot be sold. If the CIRP commences, right? Supposing the CIRP commences before the bank or any other person has taken custody and control of that asset, so they cannot recover, they cannot sell that property because then IBC bars that. That is what we are trying to say. In fact, there is another judgment. I'll show you one more judgment, which is very interesting judgment. What happened in that? The bank had taken custody under SURFACE, right? And they issued an e-auction notice also. And in fact, e-auction notice, and they sold the property even before the CIRP started, right? So they sold everything and they received, say, 50% of the money. So balance 50% was to be received only. Now, what happened? The company comes under CIRP. And the balance amount is taken by the bank after the CIRP started. They say we can receive it. Now, the big question is whether you see such a sale is concluded or such a sale is not concluded. The Supreme Court has given a judgment which says that, look, the sale is complete only when you receive the balance amount. Just merely because you have sold in e-auction notice, there is a highest bidder. He has agreed to pay certain amount and he has paid even 50% or 75% amount. But till the time the balance is received, you cannot issue a sale confirmation letter. Because the property will be transferred from this company or maybe whosoever is in possession to that buyer only after the entire amount is received, the consideration is received. So even in that case, Supreme Court has held and there is a judgment on that. We'll cover that, sir. Okay. Just give me some time. I'll show you that judgment. But it's a good point which you have raised, sir.
Thank you, sir.
Okay.
Sir, I have one question. I am
Yes, sir.
Anush Tiwari, IP.
Yes, sir.
Sir, actually, what happens in under Section 12A, if some fraud has happened in a company, the CIRP was initiated, but the IRP came to know that there were multi-level marketing company, they were selling deposits and it was a fraudulent company.
Right.
So, and the IRP was, when in the first UC itself, The IRP was attacked by the miscreants and the COC people.
Hmm.
And finally, it has not taken place. It cannot go ahead because when he calls for the meeting and all by email, so they don't respond. They want a physical meeting, and IRP is being threatened also. So IRP is applying to the NCLT to close it because it is almost impossible to go ahead with this.
Okay.
So how do I deal with this situation?
Okay. Sir, there are two things. Number one, you talked about 12A, you see, in such a case. So number one, if there is a case where you have actually noticed certain frauds, and then the promoters settle with the party and they go for the settlement, naturally, you will have to bring all the facts of the case before the COC, because at the end of the day, under 12A, the COC has to take a call, which is 90%. So therefore, you will have to place all the facts and then the COC will take a call. Now, having said that, like you were saying that even the meetings are not happening or whatever, some hurdles are being created. Well, what is the option available with you, sir? The option available is go back to NCLT, take absolutely, you see, directions from them that what to do in such a matter. So give them the entire facts of the case. You can file an application. You can file a status report, whatever way you want to do it. So please do that. And whatever the directions are given by the NCLT, then you have to be bound by it. So, but tell them clearly that what is happening in what circumstances.
Actually, sir, I have told them, but the NCLT is of the view you give us the precedence to close it. So I told that there is no precedence. So let's see, sir. The bench has changed, so the view may be.
I'll tell you, sir, how to counter this argument, because in one of my cases also, because every bench wants precedence, right? So therefore, your bench is also wanting precedence. So in one of my cases also, when IBC was very new, so one of the bench said, Mr. Makhija, do you have any authority on this? Do you have any precedent? The same question was asked. So I said, my lords will set the precedent.
Okay, sir. Right, sir. We'll do that way. Thank you.
उनके कॉलर खड़े हो गए, उन्होंने कहा हाँ, my lord, we will set the precedent. So I think you can also take the same plea that my lord should set the precedent in this manner. Okay.
Right. Thank you so much, sir. Thank you so much.
Good question. I think this is exactly, friends, what we want. What exactly is happening in NCLTs and what exactly is happening in CIRPs, along with the jurisprudence. I think that's what gives us a great learning. Okay, let's move forward. Yeah, Kotak Mahindra versus Q Precision. It is 5th August 2022. And citation is also given. You may or may not note it down because I think these slides will be with you. So I'll hand over all these slides. Okay, let us look at straight away on the ratio, because you see there is nothing much in the facts of the case. Let's try to understand this. Now here, section 25(3) of the Indian Contract Act was compared against section 18 of the Limitation Act. Let me tell you briefly what are the facts of the case and what is meant by section 25(3) and 18. I think my friends are aware about section 18 of the Limitation Act. Section 18 of the Limitation Act talks about acknowledgement of the debt, right? So let us take an example. If the company, corporate debtor has taken a loan, say on 1st January 2016, right? So what is the, and this loan was to be repaid, say on 1st January 2017. So on 2017, company does not pay, there is a default. Now, the lender who has given the money, or the financial creditor, let's assume, can start the proceedings within the limitation period. And we know that limitation period under Article 137 of the schedule, which is attached to Limitation Act, is 3 years from the cause of accrual of the cause of action. The cause of action here is the default. So from 1/1/2017, 3 years are given to the financial creditors. And not only under the IBC, even to recover to file a money suit also, for recovery of the money, 3 years time is there. So they must either go to the civil court or start IBC, whatever they wish to do. But the time limit is 3 years. Now supposing, so it is ending on, say, 31st December 2020. Say, let's assume from 1st January 2017, 3 years, 31st December 2019, sorry, not 20. So 1st January 2020, let's make it simpler. 1st January 2020. Now, supposing on 30th December 2019, just 10 days before when the limitation was expiring, the company acknowledges that, look, I owe this money to you. Then the law says, section 18 says that the limitation starts again from that particular date. That means now the limitation will now commence from 30th December 2019 plus 3 years. That is, it will go up to 30th December 2022. But section 18 has got 3 clauses which need to be satisfied, 3 conditions. Number 1, the acknowledgement of debt must be in writing. It can't be verbal. It can be through email, that's all right, but it has to be in writing. Number 1, signed by the borrower, the person who has borrowed the money. So on behalf of the corporate debtor, either it should be one of the directors or whosoever is authorized to sign. So therefore, you see, it must be signed by the borrower. And the third condition is it must be given before the expiry of the limitation period, before it becomes a time bar debt. So here it was becoming time barred on 1/1/2020. It was given 10 days before, so it is valid. So now the limitation commences again and 3-year period is given. Again it begins. So I think this is section 18. So we are all aware of this. Now come to section 25(3) of the Contract Act. What does it say? Now it is little different. Now what it says is, supposing the debt has become time barred, say 1/1/2020 has passed. Now on 1st February 2020, 1 month later, the corporate debtor enters into an agreement with the borrower, with the lender, that, okay, I will pay you this amount. Say against, say 10 crores, he says, okay, I'll pay you 8 crores. So it is a time bar debt which is agreeing to pay. Now somebody can say that this contract is without consideration, because every contract must have some consideration, and a time barred debt cannot be a consideration, because the debt which cannot be recovered, can it be, be part of the contract? But there is an exception which is given in 25(3). So 25 clearly says that any contract without consideration is void, but these are the exceptions. And 25(3), my dear friends, gives an exception. It says that when an express promise is made to pay a debt which is time barred, now that is a clear-cut contract. So this is what the issue which has been decided here. Let us look at what are the ratios. Both promise and acknowledgement in writing signed by a party or its agent authorized in that behalf have the effect of creating a fresh starting of limitation. So Supreme Court is saying under 25(3) and under section 18, under 18, if you give acknowledgement, it starts fresh limitation. Supposing you sign an undertaking or say promise to pay or an agreement, let us say agreement to pay a time bar debt, it is also a contract. So your now limitation starts from that date, right? But the difference is that an acknowledgement under section 18 of the Limitation Act has to be made within the period of limitation. So before the period of limitation expires, only then section 18 comes into play and need not be accompanied by any promise to pay. But on the other hand, 25(3) is attracted of the Indian Contract Act. Now, 18 is of Limitation Act and 25(3) is of Indian Contract Act, is attracted when there is an express promise to pay a debt which is time barred or any part thereof. Promise to pay can be inferred on scrutinizing the document. So you may word the document differently, but it can be interpreted by the courts. But the only condition is that the promise must be clear and unconditional. There should not be any conditions attached to it. So this is you can say the difference between 25(3) and 18 has been explained. Now the Apex Court was of the view that NCLAT has erred in closing the CIRP proceedings without giving the appellant financial creditor the opportunity to explain if there was a sufficient cause for delay in approaching the NCLT. Now, what had happened? NCLAT said that here there was a question of limitation, right? Because why section 18, 25(3)? Because we are talking about limitation. It extends the limitation period. So what had happened was that the NCLAT ultimately came to a conclusion that it is time barred, it is beyond the time limitation period. But they did not ask the financial creditor that, look, do you have any sufficient cause for that delay in approaching the NCLT? Now, I'll come back to Section 5 of Limitation Act. Friends, this is very interesting. Section 5, obviously, the suit is to be filed. What is limitation period? You have to file a suit or any proceeding before the limitation period expires, isn't it? But if you do not do that, then Section 3 is subject to Section 4 and 22 of Limitation Act. And 4 to 22 gives you exceptions. Right? Supposing the last day is falling on the day when the court is closed, say it is a Saturday. So when you can file it, because next day is Sunday, again the court is closed, so now your limitation automatically expires till Monday. That means you can file it on Monday. Or if it was, supposing Monday was also a national holiday, so you can do it on Tuesday. So this is one exception. I'm just giving you one exception. But Section 5 says that, look, supposing you are not able to file in time, you can still file an application under Section 5 to that particular court, including NCLT. So even in CIRP, friends, mark my words, you can go to the NCLT and say, look, I am delayed by 2 days, 3 days, 5 days in filing my CIRP application. Please condone the delay because of the sufficient cause which I am giving to you. So the person who is filing the application has to explain the sufficient cause. And if the court is convinced, well, that ends the matter. And now the big question arises is whether Section 5 also gets attracted in IBC proceedings. The answer is yes. And this was clearly laid down in BK Educational Services Society versus Parag Gupta, Supreme Court judgment. You know that on, the first case under limitation. So in that case, the Supreme Court clearly decided that Section 5 of the Limitation Act is applicable. So now what is the takeaway, friends? That supposing you were supposed to file in our case by, say, 1st January 2020, this was to be filed. The person approaches the NCLT on, say, 5th January, 4 days delay. Now, one can say, oh, it is time barred, so application limitation, it should be rejected. But if you are the applicant, you can also move an application, give them a sufficient cause, and then say, look, I was not able to file it because of these reasons. I was in hospital. There was some tragedy in my home or whatever. I mean, whatever reasons you can give, but there should be plausible good reasons. I mean, I can't say that I was traveling to Singapore, therefore I could not file. No, that will not be a good and sufficient cause. So give a good and sufficient cause, and then the court or NCLT even can also entertain that and say, yes, I'm condoning that delay under Section 5. So here, the Supreme Court said that before rejecting on the grounds of limitation, NCLAT must have heard the financial creditor on the sufficient cause grounds under Section 5. Now you must be wondering that why the NCLAT should ask it. Was it not the duty of the financial creditor to make an application under Section 5? Now there is Lakshmipad Surana judgment of the Honorable Supreme Court is there, which says that you need not make an application under Section 5. He says, look at Section 5 of Limitation Act, where it is mentioned that you have to move an application. He says, if you make a simple submission that, look, my lord, these are the sufficient causes, please condone that delay, it is good enough. You need not file a separate. This was also has been rendered by the Supreme Court in one of the IBC matters. So anyhow, be that as it may, I will suggest, my friends, that if you are delayed, please move an application under Section 5 also. I mean, don't presume that without filing, the bench will ask you. That is not going to happen. So that's a practical, down-to-earth solution which I'm giving. But here, the Supreme Court said NCLAT must have given an opportunity before doing this. Before the rejection of their application, they must have given an opportunity. Because if you look at Section 7, subsection 5, now from where they are coming? We just read 7.5a, where the word may is there. But now please read the proviso which is underneath there. So under Section 7.5, there is a proviso. Let us read that proviso. The proviso says provided that the adjudicating authority shall, and here there is shall, so it is mandatory, before rejecting the application under clause B of subsection 5, give a notice to the applicant to rectify the defect in the application. So they say, if it is barred by time, it is a defect. So this defect could have been cured by giving an opportunity of 7 days to the applicant, financial creditor. I mean, curing the defect means they must be able to explain and give sufficient cause. So this was the thinking on the interpretation of the Supreme Court. I hope I'm clear, friends. So please read 7.5 proviso, which is linked with B, that if you are admitting, then it is fine. But if you are rejecting, and if you find there is a defect, and even barring limitation is also considered as a defect as per the Supreme Court. So they say you must give an opportunity to the opposite side, I mean the financial creditor, to explain whether there was a sufficient cause or not. So if there is a sufficient cause, you must consider that. You must decide that first. If you are not convinced, then you can reject it. So friends, this is very interesting interpretations and judgments of the Honorable Supreme Court. But again, all I'm saying is you have to know about the Indian Contract Act 25.3. So it will force you to read 25.3 today. It will force you to read section 18 of Limitation Act. It will also force you to read section 5, read with section 7.5 proviso of IBC. I hope I'm absolutely clear. I typically go back to the background so that I'm able to explain the whole, jurisprudence there. Okay. Let us move to the next judgment. Peer, do you want me to take a break in between?
Yes, sir, you can take a break of.
Okay. Okay, let's do one thing. We started at 2. We'll take a break at 3:30 then, right?
Okay, sir.
Yeah, just remind me when it is 3:30, because sometimes when I start speaking, then I don't stop. Okay. Okay. So the next case is Asset Reconstruction Company India Limited versus Tulip Star Hotels. And this is AIR 2022 Supreme Court 3559. It is 1st August 2022. Now, friends, this is also a very, very interesting judgment. Here, the question is, because you see, one thing we are very clear, because most of the courts have said that when the bank declares an account as an NPA, that is considered the date of default. And typically, we always calculate 3 years time period from the date of, NPA. In fact, according to me, it should not be the date of the NPA, it is the date of default. Because you see, what happens is, NPA, an account becomes an NPA after 90 days. Right? You were supposed to pay on 1st January. You did not pay. And 90 days have expired. You have not corrected that default or defect. So now the bank you automatically become an NPA account on, say, 31st March 2020. So 1st January to 90 days, 31st March, you can calculate, right? It's 90 days, it is not 3 months. So it can be 30th March also. So let's presume that. So generally people are under the impression that 3 years to be calculated from NPA, but according to me, IBC says it is a date of default, which is sacrosanct. And not IBC says, even Supreme Court says in number of judgments. The date of default is the sacrosanct date. And date of default will be the first default, isn't it? It can't be, the NPA declaration. Anyhow, but here the facts of the case are that CD was declared NPA on 1st December 2008. Now on 7th February 2011, which is within 3 years, right? The corporate debtor acknowledged its liability and proposed a settlement. So if a CD is proposing a settlement, naturally it is admitting its liability, isn't it? And then this request was followed by further requests of extension to make times and revise settlements. Now on 1st July 2013 also, the CD acknowledged its liability, right? The corporate debtor, and then there is another fact that the corporate debtor acknowledged the liabilities in the financial statements from 2008-9 till 2016-17. Now here the question arises is, friends, that's an important fact. The application under Section 7 was filed on 3rd April 2018. So let's understand the dates again. NPA on 2008, so obviously 3 years expires in December 2011. But prior to that, the corporate debtor acknowledged liability on 7th February 2011. Now it will be 3 years from 2011. Then another fact which is given is that on 1st July, again, they acknowledge the liability, 1st July 2013. So 1st July 2013 plus 3 years is equal to 1st July 2016. Now here, CIRP application was filed on 3rd April 2018. That means almost after 2 years. So should this be admitted or should it be a time-barred application? But here is another fact that in the balance sheet, the acknowledgement of the debts is there. So now the big question arises is whether an acknowledgement of a debt in a balance sheet can be considered as an extension of limitation period as per Section 18. Because I told you 3 conditions are there. It must be in writing, signed by the borrower, and then it must be done before the expiry of the period of limitation. So now this big question was there. In fact, NCLAT, they considered this question in a larger bench, 5-member bench, right? They constituted a 5-member bench to consider only one question, whether acknowledgement in a balance sheet is also considered as an acknowledgement of debt or not. And ultimately, they arrived at a conclusion saying that it does not. It is not considered as acknowledgement of debt. Now, another bench of NCLAT, I'll just give you a small history. I think this is very interesting. Another bench of NCLAT, after this judgment came, after maybe 1 year, they thought there is something wrong in this judgment. And this 3-member bench, they said, let us refer this matter to the chairperson again to constitute another 5-member bench to reconsider this decision. Right? So they referred the matter. So naturally, when the matter is referred, the chairperson of the NCLAT has to constitute another 5-member bench. So he constituted it. Now this 5-member bench did 2 things. The new one, they said, look, insofar as the earlier decision is concerned, we are upholding it. We are not changing it. Number 2, they did a very interesting thing. They passed strictures against these 3-member benches, three members who referred the matter to them. They said, look, 5-member bench had already decided. Where was the occasion of referring it back to another 5-member bench? You should have maintained the judicial discipline, and they actually passed strictures. So please understand, some members of NCLAT are passing strictures against their colleagues, against their fellow members. Now, this is a judgment of Bishal Jaiswal. I'm referring to Bishal Jaiswal judgment of NCLAT first. Naturally, the 3 members against whom these strictures were passed, they filed a separate writ petition to the Supreme Court, and they got those points deleted. They said, whatever strictures have been passed, Supreme Court said, sorry, we are deleting those. So they were scraped off from the order. Now, naturally, another Bishal Jaiswal judgment was challenged before the Supreme Court. And in Bishal Jaiswal, I think my friends are aware that this was a question whether balance sheet is an acknowledgement of debt or not. Right? And ultimately, the Supreme Court said, yes, it is an acknowledgement of debt. But then, friends, there is a word of caution which has been added. That means that, look, in a balance sheet, because one argument was given that while preparing the balance sheet, if some amount is shown in my books of account, naturally I have to show in my balance sheet as outstanding loan or something. But supposing I'm disputing that loan, I'm not agreeing with that note, but my trial balance shows is obviously I have to reflect in balance sheet. So along with the balance sheet, I also give a note giving a dispute in the notes to accounts on in my board of directors report. So it's a qualified acceptance. So the Supreme Court has recognized that. They say if it is an unconditional and unqualified acceptance in the balance sheet, then it is considered as an acknowledgement of debt. But if it is a qualified acceptance, that means you have added some note in the notes to accounts that, look, we are not admitting this amount because of this dispute, you must write that. Then the Supreme Court says it cannot be because the acknowledgement has to be unqualified. So here in this case also, there was an acknowledgement of the debt of liabilities in the balance sheet or the financial statements from 2008-9 to 2016-17. So what will be the status? If it is unqualified, then it will be treated as that you are admitting, and then your limitation will start from the last date of the balance sheet. Supposing 2016-17 balance sheet is signed, say in September 2017. So now 3 years will begin from September 2017, it will go up to 2020. And then the application under 7.2, which is in this case, will be held to be within the limitation period. So here the question before the Supreme Court was similar, whether the debt is time barred. So here the Supreme Court has very clearly mentioned that IBC does not exclude the application of section 14 or 18 or any other provision of Limitation Act. So they say section 14 of limitation, section 18 of limitation equally apply. Section 18 talks about the acknowledgement of debt. Section 14 talks about pursuing the, filing a suit or filing a proceeding in a wrong court. So like, supposing I was supposed to file within 3 years, I filed it, but mistakenly I filed it at a wrong court, which did not have the jurisdiction. So section 14 says if you are pursuing the proceedings in a wrong court, and if you get it transferred to a right court, then that period which you consumed in filing a wrong court will be excluded. This is also an exclusion. So section 14 talks about that. 18 also talks about acknowledgement and any other provision. So what they are saying effectively is that all the provisions of the Limitation Act equally apply to IBC. So you can take benefit of any exclusion which is given in Limitation Act. This is what the ratio of this judgment. Number 2, in our considered opinion, an application under section 7 of the IBC would not be barred by limitation on the ground that it when we filed beyond a period of 3 years from the date of declaration of the loan as NPA, if there was an acknowledgement of debt by the corporate debtor before the expiry of the period of 3 years, in which case the period of limitation would get extended by a further period of 3 years. I think this is what we have discussed so far. So we are clear on that. So it is not the date of the NPA which is sacrosanct. The Supreme Court says, well, normal circumstances, it is sacrosanct, but if you give an acknowledgement, then of course it gets extended limitation. So this is what the entire ratio of this Supreme Court judgment is there. Okay. Okay, so let me deal with this judgment and then we will probably take a break in between. So 6 minutes are still left. So SS Engineers versus Hindustan Petroleum Corporation. This is 15th July 2022, AIR 2022, SC Supreme Court 3559. Okay. Let us look at what happened here. Again, well, this is a very small case, but let us try to understand. NCLT Kolkata, they admitted an application under section 9, right? And the name of the corporate debtor is HPCL Biofuels Limited. And the operational creditor, of course, was SS Engineers. Now, HPCL Biofuels was a wholly owned subsidiary of Hindustan Petroleum Corporation, which is a very large, corporation. So it was a 100% subsidiary. The NCLAT allowed the appeal which was filed by HPCL Biofuels, and they set aside the NCLT order on the ground of pre-existing dispute. Naturally, if there is a pre-existing dispute, naturally this needs to be considered. So NCLAT said you did not consider those things, so therefore the appeal has to be allowed. Now here, whether there exists pre-existing dispute and what is the role of the adjudicating authority. Now, two questions are there. In fact, they have very elaborately discussed on the role of adjudicating. So this is a good judgment to read about. If you just lay your hands on it, of course, I will be giving you a copy of it. So just read it carefully on the role of the adjudicating authority. It goes in a greater detail. I have just considered very few minor points out here. The apex court, referring to the communications between the parties and also the record, normally there's a factual position, noted that there were pre-existing disputes between the parties. So they said NCLAT is right, and there is a pre-existing dispute. Then they say, in our considered view, the adjudicating authority committed a grave error of law by admitting the application of the OC, even though there was a pre-existing dispute as noted by the adjudicating authority. So they say, obviously, when then there is a pre-existing dispute, you cannot admit that. So they say that, look, you have to do that. Now, here they are, you see, going into greater detail, what is the role of the adjudicating authority? So I'll just repeat, and in fact, this has been repeated from innovative judgments, or sorry, Mobilox judgment and many other judgments. But again, the court has given that. When examining an application under Section 9, the adjudicating authority would have to examine A, whether there was an operational debt. 2, whether that debt exceeds 1 lakh. Of course, now it is 1 crore. Then whether the evidence furnished by the application, furnished with the application showed the debt exceeding rupees 1 lakh or 1 crore was due and payable and had not been paid. So due and payable and not paid, that means there was a default. So not only the debt, you have to consider whether there is a default also. And third, they say this is most important, whether there was existence of any dispute between the parties or record of pendency of suit or arbitration proceedings filed before the receipt of the demand notice. That means a pre-existing dispute. So they say if any of the aforesaid condition is not fulfilled, the application would have to be rejected. I think we all know this, but the Supreme Court has actually repeated the whole things in this. And then they have also expanded this. In fact, there are many other paragraphs, but I'm just reproduced one paragraph, which I found to be very interesting. They say NCLT exercising power under 7 or 9 is not a debt collection forum. The IBC tackles and obligor deals with the insolvency and bankruptcy. It is not the object of IBC that CIRP should be initiated to penalize solvent companies. Now look at the words. Not to penalize solvent companies for non-payment of disputed dues claimed by an operational creditor. So they say looking at whether the debt is disputed or not is extremely important, because otherwise you will be putting a solvent company into a CIRP. So it is not to be treated as a debt collection or recovery mechanism. I think we all know this, but this has been reiterated by the Supreme Court in this particular judgment. Now, again, they have actually compared Section 8 and 9 also. They say the process, they have compared with the financial creditor and operational creditors CIRP. So they say there are noticeable differences. In Section 9, it is to be preceded with a demand notice. And if you don't make a payment, then it is considered as a non-payment, and then the application can be filed, because then if the debt remains unpaid. For IBC does not countenance dishonesty or deliberate failure to repay the dues of an operational creditor. However, if the debt is disputed, the application of the OC for initiation of CIRP must be dismissed. So I think in a greater detail, they have gone into that. Please read it whenever you have a time for this particular aspect. I think this gives us a lot of clarity insofar as these things are concerned. Okay, so friends, now I think it's almost 3:30. It's almost 1.5 hours. So I think all of us need a comfort break. So let's meet after 10 minutes. I think 10 minutes should be good enough. What do you say, Pierre?
Yes.
Pierre,
Yes,
it is,
we will start at 3:40.
3:40. So just mention that in the chat box.
Sure, sir.
And I'm not taking down my PPT, because otherwise I'll again have a problem. So I'll continue to show it. Okay.
Sure.
Okay. All right. Friends, we'll meet after 10 minutes. Thank you so much. Okay, Peer, can we start?
Yes, sir. It's 3:39, sir. 1 minute left.
1 more minute. Okay.
As you wish, sir. You can, if you want to start.
Okay. Friends, I'll just request you to please come back and join and open your videos so that we can start bang on time. Yeah, it's almost 3:40 now. Okay, so we can do that, right? Okay, so friends, we have covered a lot of judgments, a lot of grums. So let's move on to the next one, which is also very interesting. It is Valal RCK versus Shiva Industries and Holdings Limited, 3rd June 2022. In fact, friends, one more aspect. On 1st September, I think another very important judgment, or rather, we have debated it too long, actually, that judgment, which is rainbow judgment, isn't it? I think everyone is aware about rainbow judgment of 1st September 2022. So I have not, you see, put it as part of the PPT because it was a very long judgment. I've got a separate PPT for that. But if you want me to cover that, of course, I've covered on many occasions. And in fact, in the last program of ICSI also I covered. So some of you might be a part of it. If you still wish me, want that judgment to be covered, I will definitely cover that. Okay. But let me cover other judgments because that has been very widely debated and discussed. So probably many of you are aware about that. But still, if you want me to cover certain aspects of rainbow, I'll definitely do that. Okay. So let's look at this judgment now of Shiva Industries and Holdings, 3rd June 2022. Now here, the facts are little, you see, you can say little more are there. So let us try to understand the facts of the case. That's very important. Now here, IDBI Bank actually filed an application for CIRP initiation against the corporate debtor, which is Shiva Industries and Holdings Limited. And then on 4th July 2019, the NCLT admitted, and of course, CIRP was initiated. Now, a resolution plan was presented because naturally a plan came. It was presented before the Committee of Creditors, but it was not approved by the COC because it did not get the requisite vote. That means 66%. So naturally, if you are an RP of such a company, what you are going to do? You will also file an application for liquidation. So the RP also filed an application for liquidation of the corporate debtor. Now, one of the promoters of the corporate debtor, in the meantime, filed an application under section 65, because that is the only section which is left, and offered a one-time settlement plan. Now, the COC considered the settlement plan in 3 meetings. Well, they were held between October and December 2020. And then there was a final settlement plan which was filed by the promoter on 18th January 2021. And this settlement plan was approved on 1st April 2021. Now, based on this, RP filed an application for withdrawal. So NCLT, when it was dealing with that application, it rejected that application. They said settlement plan is nothing but a business restructuring plan. And in any case, and then you see it initiated liquidation process. And then naturally the appeals were filed before NCLAT and those appeals were also dismissed. So now the promoter of this corporate debtor who proposed a one-time settlement, which was approved by the members of the COC, now he approached the Supreme Court. Now these are the facts and the background of the case. Now the Supreme Court now says that they referred to a lot of judgment. They said a lot of judgments are there of the Supreme Court, which says that the commercial wisdom of the COC is not to be interfered by the NCLT and NCLAT. So look at this aspect. Plan came, plan not approved, but then one-time settlement plan scheme was filed by one of the promoters and the matter reached before the Supreme Court. And Supreme Court now says that once the commercial wisdom of the COC cannot be touched, cannot be interfered with. by any of the adjudicating authority or appellate authorities. Now they say when 90% more of its creditors, which is the requirement under 12A, in their wisdom, after due deliberations, find that it will be in the interest of the stakeholders to permit settlement and withdraw CIRP, in our view, the adjudicating authority or the appellate authority cannot sit in an appeal over the commercial wisdom of the COC. The interference would be warranted only when the adjudicating authority or the appellate authority finds the decision of the COC to be wholly capricious, arbitrary, irrational, and dehors the provisions of the statute or the rules. So here is a judgment which upholds the primacy of the commercial wisdom. But friends, don't you think that the Honorable Supreme Court, with due respects, has gone too far in this matter? Because at the end of the day, there is no denial that the commercial wisdom of the COC is supreme. It should take primacy, no doubt about it. But here, the COC also rejected a plan. Now, after having rejected the plan, where is the question of considering a settlement scheme? And then in case of a settlement, in the facts of the case, it is not clear because you see, we are not really aware what exactly happened in the settlement. Is this promoter settling with the creditor who has filed it? Or is he settling with the financial creditors? Or is he settling with all the operational creditors also? So today in a CIRP, friends, not only the financial creditors, there are other stakeholders, including the operational creditors. Now, if you go and settle with one of the persons, so 12A was brought in that, look, you can do it as early as possible. Of course, there is no time limit which is mentioned in 12A. But here there is a case where I probably, this is my personal opinion, that the Honorable Apex Court has gone little far ahead, you see, in upholding the commercial wisdom. No doubt about that. But here everything has failed. Now they are coming with a one-time settlement. Now, one-time settlement with whom? We are not aware of the facts of the case, because it is not mentioned there. So they are simply saying they came out with a one-time settlement. 90% of the more of the creditors approved it, which creditors means the COC members only. So this was the case where it was allowed to be withdrawn and the company came back to its feet. I mean, it was outside the CIRP. So anyhow, this is one of the interesting cases which happened there. Okay, so let us move on to the next case, which is Kotak Mahindra Bank versus A. Balakrishna. And this is 30th May 2022. So let's look at what are the facts of the case. Now that's also interesting. Here, these facts are a little, you see, interesting. Again, it is on the question of limitation. But here, the question is a little different. So let me explain it to you rather than reading it. Now, Kotak Mahindra Bank, what they had done is, they had filed applications before the DRT.
What she's up to. You see, because of why you don't get an invitation to actually talk to her because she never comes.
But you never like talking to her.
No, but you have to know what she's doing.
Interrogating her.
Yeah. You're required to know what she's doing. That's very critical. Paila ke sath she was sitting here or she was visiting. So you relate or so. It's quick everyone to get a feel of what she's doing.
Participant.
Yeah, thank you. I think, friends, may I request everyone to please keep their mics muted because background noises definitely disturb us. Okay, thank you. So, friends, Kotak Mahindra Bank initiated proceedings against the corporate debtor by filing applications before the DRT, recovery suits, right? Now, what happened? These applications were allowed. So they won the case. And then naturally, I think my friends are aware, when a DRT application, DRT, you see, gives a decree or a judgment in the favor of the creditor, then they issue a recovery certificate. That means now they issue an RC. That means now you can recover that amount. So RC was also issued. And in the meantime, Kotak Mahindra also filed an application under Section 7. And they were trying to recover the amount, which is a very large amount, 835 crores, right? And this CIRP was admitted on 20th September 2019. because the recovery certificates were issued, you see, in 2017. And then this application was admitted or filed on in 18. So then appeal was filed by one of the directors of the corporate debtor before the NCLAT on the ground that the application under section 7 is time barred. What was the time barring? They said, look, the date of default is sacrosanct. So the date of default was much earlier. Now, Kotak Mahindra took a stand that, look, there is a recovery certificate in my favor by the DRT. So if there is a recovery certificate, the amount has been, you can say, determined by the DRT and this date. So my limitation will start from the date of the recovery certificate issued by the DRT. But otherwise, the date of default was beyond the period of limitation. So NCLAT said that, look, Supreme Court has said in number of judgment that date of default is sacrosanct. The issue of recovery certificate by DRT has no meaning. So therefore, we are allowing this appeal. So they allowed the appeal and the CIRP was closed. Now, naturally, Kotak Mahindra came before the Supreme Court. So here the Supreme Court, what it says, look at this. They says now they are looking at you see, amount which has been crystallized. So they are looking at the crystallization of the amount by the DRT and they are comparing in view of section 5(8), which is the financial creditor and financial debt definition which are there. Considering the object and purpose of the statute, the court was of the view that section 5(8) would include a debt which has crystallized in the form of a decree. So they say that if a decree is passed today, which is on the date when the decree is passed, or a recovery certificate is issued for that matter, then the amount is said to be crystallized on that date. So therefore, the liability in respect of claim arising out of a recovery certificate would be a financial debt within the ambit of 5(8). And the holder of such certificate would be considered as a financial creditor under section 5(7) of the IBC. So friends, here there is a slight change. Number one, the date of default is sacrosanct. There is no doubt about it. So the time limitation will start from the date of default unless it has been acknowledged, right? Acknowledgement of debt, either in writing before the expiry of the limitation period or in any of the balance sheets. So that, of course, we are aware of that. But now this is something new now. Now here there are two things which I want to clarify, right? Two things I would like to deal. First thing is that while you have started, you have not started CIRP and your 3 years time period has gone and the bank has already started, say, DRT proceedings. So does the pendency of the DRT proceedings extend the time of limitation? The answer is no. So while the proceedings before the DRT are pending, you cannot take advantage of the fact that it will be counted as it will be excluded from the period of limitation. No, it will not happen unless you are able to demonstrate to the court that under section 14, you have gone to a wrong court, but it is not a case of that. Now, having understood that, but supposing the DRT proceedings culminate into a decree or a recovery certificate, then the Supreme Court says the position changes. That means now this will be considered as a crystallization of the debt, because now this is the recovery. This is the, now here, once the recovery is there, you will definitely have to pay it. So therefore your date of default starts from the date of, decree. So therefore they say date of default, the crystallization of the debt in the form of a decree will begin a fresh period of limitation. This is what the Supreme Court has mentioned in this particular judgment. Okay, I hope I'm clear, because on limitation, friends, there have been a lot of issues, but this is one of the issues which is extremely important. Okay. Okay, now let's move on to the next judgment. State Bank of India versus Krishidan Seeds. And this is 18th April 2022. Judgment is there. So let's look at the facts of this case. Again, you see, it was on the ground of limitation only, because on limitation there have been number of judgments. Okay. So here NCLT rejected the application under Section 7 filed by SBI on the ground of limitation, right? And they said that a statement or acknowledgement of debt given in a balance sheet cannot be an acknowledgement of liability. And then even NCLAT also held that it will not be treated as, you see, Section 18. I mean, the balance sheet acknowledgement liability reflected in a balance sheet will not be treated as a Section 18 acknowledgement of debt. But anyhow, the Supreme Court, in a very, very, you can say, short judgment, they have clearly said that, look, this issue is no longer Resi Tigra, Lakshmipat Surana, Bishal Jaiswal, Sheshnath Singh. Three and many other judgments are there, right? So all these judgments, I'm showing it to you before you see on your screens. So you must read these judgments. These are very interesting. Lakshmipat Surana, Bishal Jaiswal, and maybe Sheshnath Singh. So these are the three judgments which are absolutely clear and which tell us that balance sheet can also be considered. So look at this. An acknowledgement in a balance sheet. Now, this was what I was talking about. Acknowledgement in a balance sheet without a qualification can furnish a legitimate basis for determining as to whether the period of limitation would stand extended, so long as the acknowledgement was within the period of 3 years from the original date of default. So I hope I'm clear on this. The provisions of Section 18 of the Limitation Act are not alien to and are definitely applicable to proceedings of the IBC. In fact, all provisions of the Limitation Act are applicable to IBC. An acknowledgement in a balance sheet without a qualification can furnish a legitimate basis, right? So this is, I think, we have already looked at it, so I'm not repeating it. In fact, this paragraph is repeated here. So friends, this was again on limitation and on the acknowledgement of debt in the balance sheet. So in the balance sheet, if it is without a qualification, then it can give you the basis of extension, right? So I hope, I think we have already discussed this issue. So let's go to another interesting judgment, which is Indian Overseas Bank versus RCM Infrastructure, which is 18th May. Okay, I'm actually going backwards. So I started with the later judgments and I'm going backwards now. Now here. Now this is the case, sir. I think one of our friends was talking about the Revenue Recovery Act, and then I mentioned that e-auction notice was issued. So this is the case which I'm mentioning. Okay. So just note it down this case if you wish to. Okay. Yeah, so this is the case, IOB versus RCM Infrastructure. So please note down, this is a very interesting case. Now what had happened? IOB, of course, had given some loan facilities. SARFAESI were initiated. Then bank took the possession. And then in their exercise of powers under 13(4) of SARFAESI Act, they did that. And then they also came out with the e-auction notice. So that the money can be recovered, right? Then you see, while that was being done, and the application was filed before the NCLT for admission, and on 3rd January, now this is an interesting date, 3rd January 2019, NCLT started CIRP process. They admitted the petition and moratorium was also notified. Now, after that, the allegation is that the bank continued the auction proceedings and they accepted the balance 75%. So 25% they had accepted prior to the commencement of CIRP because the sale was, the auction and the highest bidder, the sale was confirmed in his favor. I mean, kind of that you are the highest bidder and you can take this property. So 25% was accepted. 75% he took some time to pay. In the meantime, the company came into CIRP. And then even after the CIRP started, the bank accepted the 75% amount and then they completed the sale, right? NCLT, when an application was made by the RP, NCLT set aside the sale. But NCLAT, right, NCLAT also dismissed that appeal. So they upheld the order of the NCLT. And then definitely now the bank, which is an aggrieved party, IOB, they approached the Supreme Court. So here what the Supreme Court says, look at this. After the CIRP is initiated, there is a moratorium for any action to foreclose, recover, and enforce any security interest created by the corporate debtor in respect of the property under SARFAESI Act. This is section 14(1)(c). I think everyone knows about it. It is clear that once the CIRP is commenced, there is a complete prohibition for any action to foreclose, recover, or enforce any security interest created by the corporate debtor in respect of its property. So there's a word including any action under SARFAESI are significant. So there's a legislative intent is clear. So nothing can be done. So regardless of the fact, and the sale gets concluded upon when the final amount is completed. So here it says the sale under the statutory scheme as contemplated under Rule 8 and 9 of the said rules would stand completed only on 8th March 2019. That means when you are admitting the balance amount, when you are accepting the balance amount. And they say this date falls after 3rd January 2019, which is the date of CIRP. So therefore, the appellant bank should not have continued with the proceedings under SARFAESI. So therefore, the order of the NCLT and NCLAT, we are upholding that. So I hope, friends, this is a very interesting judgment. This was what we were discussing. So you can note down this judgment. Okay. Now, friends, this is a judgment which actually affects the real estate matters. This is New Okhla Industrial Development Authority. In short, we call it as Noida, which is, surrounding the Delhi. So the people who are living nearby Delhi, they are really aware about this word, Noida, versus Anand Sonbhadra, which is a company. And this is Anand Sonbhadra was the, RP. And this is a judgment of 17th May 2022. Now here, what is the fight? The fight is, let me give you an example, the brief facts rather than reading it. Noida is also an authority which actually gives the land for developing it. For building the flats and development. Otherwise, they give it on lease, right? So they are the owners. They have got a freehold property, but when they allot in the form of a lease for 99 years. So it's not you can say outright sale to the companies or the parties, but it is a lease agreement for 99 years. So now, once they have executed a lease deed, the question that arises is whether the Noida, because now there are lease dues which are there, right? So you have to pay monthly rental charges or annual charges, lease charges. So those annual charges, naturally, Noida will file a claim. Whether Noida will be considered as a financial creditor or as an operational creditor, that is the big question. So it will impact, most of the real estate matters where the property is taken on lease. So whether the lessor will be treated as a FC or an OC. So here, that is the question. Now here, what had happened is there were two contrary judgments, right? Noida, in one of the cases, bench 4 of New Delhi bench, they said Noida is an operational creditor because they said the lease which has been executed between the Noida and company, it is not a financial lease as per the accounting standards. And then it was also affirmed by one of the orders of the NCLAT also. But then NCLT principal bench, in one of the cases, now it held that Noida is a financial creditor. So there were two differing judgments of the two benches. Of course, NCLAT has also held that, look, it is, operational creditor. But then this order was challenged, naturally. So NCLAT put a stay on that. But in between, then Noida authorities approached the Supreme Court straight away. And NCLAT held that Noida is an operational creditor under IBC and cannot be considered as a financial creditor. Now, Noida wants itself to be a financial creditor, isn't it? So that is why they approach the Supreme Court. Now, what happens? These are the three issues which are to be decided. First is whether the appellant, that means Noida, is to be treated as a financial creditor within the meaning of IBC. That is the first question, which is a major question. The second is whether the Noida is a financial creditor under section 5(8)(d) of the IBC. Now, financial creditor, you can be a financial creditor under any of the clauses. So they are claiming that, look, we are financial creditor under two clauses, 58D and 58F. So now the Supreme Court has to consider both. So there is a huge discussion on both these aspects. Now, Supreme Court naturally looked into the Indian accounting standard. So those who are aware about the accounting standard, so they might be knowing that there is an accounting standard for leases now, which actually gives you the characteristics of a financial lease. So Supreme Court referred to para 63, and they said lease will be a financial lease if the term of lease is for major part of economic life of the underlying assets, even if the title is not transferred. So please understand this, friends. So supposing there is an underlying asset, here it is a land. It can be building also. It can be plant and machinery also. Now, naturally, a plant and machinery and a building has naturally got some life, right? So plant and machinery, let us assume it has a life of 20 years. Say building has got a life of, say, 60 years, right? We are just presuming. So if the building is leased to someone, say for 50 years, right? So what is the economic life of the building? 60 years. So major part, 50 years, it is leased, then it is considered as a financial lease. Otherwise, it is not, right? So even in the case of, you can say, plant and machinery, the same thing can happen. Now the question is, what is the economic life of a land? Does the land have an economic life? The Supreme Court said that the land does not have an economic life. It goes on for years and years, isn't it? Where is the land is going to go? And the value of the land never depreciates, it always appreciates. So therefore, even if the lease is for 90 years or 99 years, now we cannot say that it is for the majority of the part of the economic life, major part of the economic life of the land. So therefore, they said that the lease which has been entered by the Noida authorities is an operational lease and it is not a financial lease under 58D. So 58D is settled, right? Because 58D, if you look at, it talks about financial lease. So this is what they have mentioned. I think I have given an example. So therefore, I don't need to read this. Now coming to 58F. Now 58F, what is the 58F? 58F says amount borrowed for any other, for the commercial purposes, right? Raising the amount for a commercial purpose, having the commercial effect of a borrowing. I think my friends are aware. So now they are saying that we are unable to uphold that the lease has raised any amounts from the appellant. The question, therefore, of considering the last limb of 58F, namely whether it has commercial effect of borrowing, could not arise. Now, why they are coming to this conclusion? They say Noida authorities has given a land on lease. Where is the question of money being raised on having the commercial effect of borrowing? So it does not arise. It does not fall under that. Now, naturally, lessee is supposed to pay some rental or some premium. Now, that rental or that premium cannot be considered, you see, as an amount raised by the lessee from the appellant. Rather, here the lessee is paying to the lessor. The company is paying to the Noida authorities. Company is not getting a benefit. Company has not raised any funds. So even 58F logic was also rejected. So considering both 58D and 58F, my dear friends, the Supreme Court said that Noida authorities are to be considered as what? Operational creditors. Okay. So this is very, very important. But the things can change in case of a leasehold of building or plant machinery or vehicle or something, because then you have to see whether it is for the major economic part of the life of the asset or not. Okay. Now, friends, let us look at 29th April 2022 judgment, Sapphire Technologies versus Provident Fund. Now, Provident Fund has been a very, very hot topic in most of the judgments, or I mean and they have become very active, particularly after Rainbow. So let us look at what happened in this particular case. Now here, the plan was approved by the Committee of Creditors and NCLT also approved it. So the date of approval by NCLT is 22nd October and by COC it was 6 months earlier, 4th April of 2019. Now, what happened here is, now this is very interesting. The RPF commissioner they filed a claim before the RP on 9/10. That means after the approval by the COC, but before the approval of by the adjudicating authority. So in between, they filed a claim, right? Obviously, RP will reject that claim. So therefore, you see, they filed an appeal, right, on 14/12/2020. So they filed a little later. And against the plan approval also, because in the meantime, the plan was approved. So they filed an appeal before the NCLAT challenging the, you see, plan approval. But it was filed after a delay of 388 days. So naturally, because they were supposed to file within 30 days plus maximum 15 days time period can be allowed as a condonation of delay, but they filed it much later. So there was a delay of 388 days. Now the Supreme Court held that the similar issue fell for consideration in the case of Kalpraj Dharmshi versus Kotak Mahindra. This is also a very interesting judgment. Now here the Supreme Court held that an appeal shall be filed before the NCLAT within a period of 30 days from the date of order passed by NCLT, which is given under section 61 itself. And then maximum 15 days can be extended by NCLAT if you give some sufficient reasons. In view of the aforesaid judgment, so they just relied upon Kalpraj Dharmshi, and they just simply mentioned that we are of the considered view that the appellate tribunal committed an error in issuing a notice in the appeal. So what the NCLAT had done, they did not actually decided the appeal because it was an initial stage. They issued a notice, despite the fact it was filed after 388 days. So this was challenged. And the Supreme Court said, look, how can you issue a notice, which now they have filed an application after 388 days. Now you must consider whether it is filed within 30 days plus 15 days time. That's all maximum. So here somebody can say, oh, they could have got the benefit of suo motu writ petition of the Supreme Court, where the limitation was stayed from, you see, 1st March 2020. Well, friends, even if you exclude that period of 45 days is gone in this case. Okay, because you see what we know that the plan was approved on 22/10/2019. So if I calculate first 30 days, they expire on 22/11. If I add 15 more days, well, it will be 7th of December. So it was 7th of December 2019 by which the PF department should have filed the appeal. They filed it on 14/12/2020. So therefore, the Supreme Court said, sorry, this is not going to help you. And NCLAT should not have even issued the notice in such cases. So again, time limitation is extremely important, friends. Okay. Now, friends, I'm now coming to a very, very interesting judgment. In fact, all judgments are really interesting, but this judgment is unique. And why I'm saying it is unique, because it has actually helped me in one of my cases also, right? I'll tell you how and what this judgment is all about. So first, you just note down the name, New Delhi Municipal Council versus Minosha India Limited, NDMC versus Minosha India Limited. NDMC, those who are staying in Delhi or surrounding areas, they know that this is a municipal corporation. We have two municipal corporations. One is for Delhi and one is for New Delhi. So we call it as NDMC. Another is Municipal Corporation of Delhi, which is MCD. Okay. So NDMC is basically in charge of the New Delhi area. Now, they had certain dues against Minosha, right? And there was certain quarrel about the arbitration. So here it involves the arbitration, this thing. So let's look at the facts. The appellant had approached the Honorable Supreme Court, whereby the Delhi High Court order was challenged, allowing the application filed by the respondent corporate debtor under 11(6) of the Arbitration and Conciliation Act. Corporate debtor, which was under CIRP, now they moved an application for appointment of arbitrator, right? Which is under section 11. Now this was allowed. So the Delhi High Court allowed that. Now, NDMC went to Supreme Court saying that Delhi High Court cannot allow it. What is the reason which was given? Look at this, is very interesting. So let's try to understand. They said that the application which has been filed by the corporate debtor is time barred. Why? Because more than 3 years have gone, or whatever time period is gone. The stand which was taken by the by the council of the RP or the CD was that look, there is a moratorium. So moratorium says that continuation of the suits or filing of the new suits cannot be done. So therefore, I am filing it. It is well within time because there is a moratorium and I should get the benefit of moratorium. Now, it may sound little optimistic to you also, because what is section 14? Section 14 says that it prohibits institution of the suits or continuation of the existing suits or legal proceedings against the corporate debtor. So by the corporate debtor are not barred under section 14. So NDMC took this stand before the Supreme Court. They said, look, my learned friend cannot take, the CD cannot take advantage of moratorium, because as an RP, when you take over, you are not barred to file a suit or start the proceedings. So you should have filed within time. Why did you wait for certain more time and start the proceedings after that? And now you come and say, oh, I should get the benefit from the CIRP date till the date when the CRP is continuing, because you get the benefit, I also get the benefit. Now here, friends, I would like to draw your attention to a very, very interesting provision. I don't know how many of you have read that, but if you have not seen that, please look at section 60, subsection 6. So if you have the books before you, please open it. I think let's read it together because this is interesting. Section 60, subsection 6. Now, what does it say? It says, notwithstanding anything contained in the Limitation Act 1963 or in any other law for the time being in force, in computing the period of limitation specified for any suit or application by or against the corporate debtor for which an order of moratorium has been made under this part, the period during which such moratorium is in place shall be excluded. Right? So what does it say? What is the effect of this section 60, subsection 6? That other parties are barred during moratorium to file a suit. Supposing during CIRP period, their period becomes time barred. Like, let us take an example. I think that will be interesting. Say on 1st January 2022, CIRP gets started. Now, some financial creditor, or say any creditor, was to file a suit within 3 years, and their 3-year limitation was expiring on, say, 31st January 2022. So 1 month after the start of the CIRP. Now, naturally, because of section 14, they are barred from instituting the new suits. So naturally, they cannot file it. And CIRP, supposing it goes for 2 years, now what happens to their time limitation? Right? Supposing the settlement happens and the company comes back to its rails. Now somebody can take a stand, oh, their time limitation is gone. But section 60 comes to their rescue. Section 60, subsection 6 says that from the date of the moratorium till the time that moratorium continues, that period will be excluded. So supposing the CIRP is withdrawn, say after 1 year, say on 1st January 2023. So from 1st January 2022, 1st January 2023, that period of 1 year, which is under moratorium, will be excluded from the limitation. That means now that creditor can still file a suit by 31st January 2023. So he gets that 30 days time period there, or 31 days. I hope I'm clear on this. The logic of the NDMC was that this benefit of the stopping of the limitation period is available only to the persons who were supposed to file against the corporate debtor. Because by the corporate debtor, there was no bar. There was no moratorium, to so to say. So therefore, 60 subsection 6 must be read along with section 14, and this benefit should not be given to the corporate debtor or the RP. Right? So this was the position before the Supreme Court. Now Supreme Court has to decide. Now what the Supreme Court says. And friends, please look at section 60 subsection 6 very carefully again. It uses the word by or against the corporate debtor. In moratorium, the word is against the corporate debtor. But in section 60 subsection 6, it uses the word by or against the corporate debtor. So the Supreme Court analyzed both section 14, analyzed section 60 subsection 6, and read them in a harmonious manner and said the benefit of the extension of the limitation period will also be available to the company which is under CIRP. I hope I'm able to make it absolutely clear. So therefore, as an RP, supposing you were supposed to file a suit, right? Let's take another example. 1st January 2022, you are appointed as an RP. Now you have to recover money from, say, X. And the time limitation for filing the suit against X in the normal course is expiring on 30th June 2022. And you don't file. So the Supreme Court says you get that benefit of exclusion because even though you could have filed because there was no moratorium, but even if you don't file, you still get the benefit of section 60 subsection 6 when the moratorium is in place. And friends, mark my words, I have used this judgment in one of my cases. In fact, we have argued that matter and before Delhi High Court. Again, the matter is listed on 31st January and I'm quoting Minosha only there. Let's see what happens, and when the final judgment comes, definitely I'll be able to share it with you, but this is something which you can utilize. So don't bother if you don't file any suit or proceedings, you get the benefit of extension in the limitation period because of this judgment. So I hope I'm able to clear it out, friends. Okay. So here, this was the issue. Let's look at very quickly whether section 60 subsection 6 of IBC gives rise to a new lease of life to a proceeding at the instance of the corporate debtor, underline these words, on the basis of the moratorium which is put in place by virtue of order passed under section 14, and whether a CD can take advantage of the same to bring in application, in this case filed under 11.6 of the arbitration. So this was an issue which I just explained it to you in detail. Well, obviously they said that it can be done, and because the argument which was taken was because of moratorium mentioned in section 60 subsection 6 also, the Supreme Court said, look, as far as mentioning of the word moratorium is concerned, it is basically mentioned for computation of the period of limitation from that date. That's all. So it has been mentioned from that purposes. Otherwise, the period will be excluded for both the corporate debtor as well as the parties against the corporate debtor. So I think this was a very, very interesting, you can say, a landmark judgment to that extent. So please, friends, this is a new section 60 subsection 6, which you have not read it, probably please go through this judgment. Okay. Let's go to the next one, Narinder Garg versus Kotak Mahindra Bank. This is 28th March 2022. Okay. Now here, there is a very simple, you see, issue which was there. There were criminal complaints which were filed against the directors, right? Under section 138, in its directors. Now the question and the resolution plan was approved. So once the resolution plan was approved, now they said that the complainants, like supposing Kotak Mahindra Bank has filed. So they said Kotak Mahindra Bank has accepted the plan. So they have accepted a haircut. So therefore you must quash. Now the 138 does not lie, because primarily it was filed against the corporate debtor, and obviously the corporate debtor is gone. I mean, this case does not lie now. So therefore you must quash the proceedings against the directors also. Well, I think my friends are aware about it. So the Supreme Court said, sorry, this cannot be done. So if the proceedings against the corporate debtor under 138 are going on, now they will be under a stay because of P. Mohan Raj. But if they are also going against the directors or any other person, like any employee who has signed the check, they will continue despite the fact CIRP is going on, despite the fact that plan is approved. Okay. I hope this was a small issue in this. So I just thought I'll just mention this.
Sir, I have one small question here, sir.
Yes, sir. Go ahead, sir.
Sir, now that 138, suppose director, it's fine. If they are owner come director, it is fine. There are employee directors who would have also signed the checks. If they, in case they are like not to settle the amounts, then they will have to go back to the company to claim it back now because they have not signed it on their personal capacity.
Okay. Now, this is a very interesting question, but my dear friend, let me tell you, there is slight complexity in this. I'll explain you what is the complexity. I understand what you're, where you're coming from. Friends, let us understand what Mr. Narayanan is saying. He's saying that, look, as an employee, I signed a check because naturally employees are also the authorized signatories many times. So naturally a case is filed against them, and just to have a peace of mind, they settle. Supposing the amount was 1 lakh rupees, the employee says, okay, I'll pay from my own pocket. Now, naturally, if the employee pays from its own pocket, it steps into the shoes of the original person. And naturally, now the employee should be entitled to claim it from the corporate debtor. So this is your case, right, Mr. Narayan? I hope I've stated it correctly.
Absolutely, sir. Absolutely.
Yeah. Now, the question which arises is, see, the point is, if the plan has not been approved and in between the employee has paid, then employee can definitely file a claim. Please understand. Now, this is the position. And then, of course, his claim will be considered, and whatever is given in the plan, that he will be paid according to that. So he will not be paid the full amount, though he's entitled to claim, but he will get whatever is proposed in the plan. That is one. Two, supposing the plan has been approved. Now let's anticipate another situation, visualize another situation, plan approved, and employee pays later to that person. Now the question is whether the employee can claim it from the corporate debtor whose plan has been approved. The answer is big no. Because of Ghanshyam Mishra judgment, because of many other judgments, which says that any claim which is filed after the approval of the resolution plan, it cannot be admitted, it cannot be done. So here there is a case. Look at, I'm now talking on a bigger picture. You are on a very small amount, like check bouncing. Supposing I'm a director of a company. I have given a guarantee, personal guarantee, right? So here, supposing the amount is 100 crores. So out of 100 crores, the plan is approved for 20 crores. So 20 crores, the financial creditors get it, but now they can recover 80 crores from me. Assuming they sell my property and they recover 20 crores from me. Now I should be entitled, because now there is a right of subrogation. I should step into the shoes of the financial creditor and should be able to recover from the corporate debtor. But at the end of the day, corporate debtor's resolution plan has been approved. So therefore, there is a huge conflict. There is no, you see, conclusive judgment on this particular aspect. That look, if I'm a guarantor, so my right of subrogation, which is allowed to me under Indian Contract Act, now that has been destroyed under IBC. Now, the simple answer one can give is, oh, IBC overrides Indian Contract Act, so therefore the end of the matter. But no, I will not agree with that, because if you read 238 says, if the law is inconsistent with any other law, here there is no inconsistency. Right of subrogation is not dealt by the IBC. So how can it be done? So ultimately, Mr. Narayan, we need a land.
One more addition to that, sir. Now, because nobody's asking questions, the session is going continuously. And we are not getting benefit of you. Sir, one more important aspect of it.
Yeah.
Not only that, the right of subrogation, while in thing, can in anticipation, can we do a contingent claim? That should be permitted, otherwise no. If the result before the resolution plan, we should give the provision for the contingent claim, and they should consider it because that is something which we have to bring the amendment. It's not that all are at fault. See, the company could have gone really bad for no reason, and that because of the economic condition. But why should the the directors who may not be maybe even employee directors, why should they be penalized?
No, I really appreciate what you are saying.
Or
and
even the wanted promoted directors, why should they be penalized?
well, what you are saying is actually out of box thinking. I must appreciate that, because at the end of the day, nobody thought that, oh, contingent claim, can we make a claim? The answer is yes, you can always make a claim for contingent claim. But now whether it will fall in the category of a contingent claim or not, that's the question which we need to decide as lawyers and as chartered accountants and as company secretaries and all professionals. Now, what is contingent? Contingent is that the outcome of which is based on the happening or non-happening of any event. So here, your case, well, looking at the definition, it definitely falls in that, because a court case is always a contingent liability, isn't it? Even if the court case is going on, in the balance sheet, the contingent liability is reflected that the court cases are there, isn't it? So according to me, yes, it falls under the contingent claim. Now the question is, somebody must try it before doing it with the RP.
We should, sir, we should all take it up in our forums and ensure that this is considered by all the RPs when they are finalizing the resolution plan, that that they should. Sir, more so in the liquidation, it will become worse. Because they would have sold the assets and they would have settled. There will be no money to pay for these kind of contingencies.
And the company stands dissolved, from where you're going to claim.
Absolutely.
That's right. I think that's an interesting thing. I think Mr. Narayanan has been wonderful on these aspects. Okay, so let's move forward, friends. Now, this is invest asset securitization and reconstruction versus Girnar Fibers. So 25th April 2022. Here, you see, the question was simply because NCLAT had dismissed the application on the ground that it is barred by limitation. Again, there is a question of limitation which is there. Okay, so here, what are the facts of the case? Now, again, it was declared as an NPA, and after it was declared, okay, may I request everyone to just please mute their mics, please? There is some echo is coming. Yeah, thank you. So, okay. So the loan which was taken by SBI, now that was actually, you can say, assigned to invest asset. To invest asset, it was assigned. And then the reference which was filed by Girnar was dismissed by the BIFR. Now, after that, the invest asset filed an application on 1/10/2018. So here there was a case where the SIC industrial company's reference was filed by the corporate debtor. Obviously, naturally, the corporate debtor is supposed to file if it is considered as a SIC company. And that, you see, was dismissed. So the question is that during that period of, you see, the company was, you see, before the BIFR, now whether that period should be excluded or not. That is the question. So ultimately, the Supreme Court said that it can't be excluded. So therefore, they said that the reference before the BIFR was abated on 13/8/2015. And also the period between 25th April 2006 and 4th May 2016. That means the declaration as a SIC and then dismissal of the reference, it cannot be excluded for computing the limitation period. So again, it is on limitation, but here there is a slightly different issue, because if the company was under the SIC Industries companies before the NCLAT. So that is the small differences there. Okay. Let's go to the another one, Sunil Kumar Jain versus Sundaresh Bhatt, 19th April 2022. Okay. Now this is a very interesting thing, and I think most of the RPs will also get a benefit of this. It's very interesting. And this is a landmark judgment. Now the question is that you become, supposing, like I'm just giving you first the facts or the example, that you become the RP of a company. You do not run it as a going concern. Despite your best efforts, it is not made as a going concern. Now, there are certain workmen or employees on the rolls, right? Now, naturally, if the company is not a going concern, they are not working. And the second question can be, company is a going concern, but despite that going concern, there were 100 employees on its rolls, but only 20 were actually working. but 80 were not terminated, right? So there is no termination or dismissal. So the question that arises is, what happens to the salaries and the wages of the people who were employed by the corporate debtor and they were just sitting, not actually working because the company was not a going concern, first instance. Second, it was a going concern, but not all were working. So some were working and some were not working. So the question that arose before the Supreme Court, that whether the wages and salaries of such workmen who have not worked at all during CIRP, but they were on the rolls, should that be treated or included in the CIRP cost? Now that is a big, big question because everyone is worried, right? And everyone, all NCLTs and NCLATs are very soft corners for the workmen and the employees. But here comes Supreme Court, my dear friends, and Supreme Court says that the per workmen or employees who have not worked at all during the CIRP, they will not be entitled to any salary, any wages, and it will not form part of the CIRP cost. This is a fantastic judgment to that extent.
Sir, which is the case law for this, sir?
Yes, sir. I'll just mention that. This is a case law of Sunil Kumar Jain versus Sundaresh Bhatt. 19th April 2022, 2022, 7 SCC 540.
Sir, hope you will share with us all these.
Absolutely. Sir, you need not note down. This
Please.
PPT has been made for all of you. It's not for me. Okay. So I have a complete record of sharing my knowledge. Don't worry. Okay. And in fact, not only I'm sharing the PPT, I'll share with the complete set of the judgment.
Sir, also your contact details so that we can bother you, sir.
Okay. That, of course, I'll share in my chat box. Okay. Okay. So this is one of the things. I think I don't need to really go into the details, but the Supreme Court also said that naturally the RP must make an effort to make it as an going concern. So even if he is not able to make it going concern, then he will not make the payment to the salary to the workmen or the employees if they are not actually working. If they are actually working, right? Supposing you are taking help of two people like an accountant or something, obviously, naturally, you will have to pay for that. So this is the logic which has come. But they say that the position will be different in this thing. Right. And they say that if they are going like I'll just read the second sentence. Only with respect to those workmen or employees who actually worked during CIRP, when the CD was a going concern, their wages, salaries are to be included in CIRP cost, and they shall have first priority over all other dues as per section 53(1)(a). So even in liquidation, none of the employees or the workmen can claim for this period. Okay, for obviously prior to ICD, naturally they can file a claim, but not during the CRP if they are A, not working, or B, the company is not working as a going concern. So this is a very, very interesting judgment. I think you must note this. Okay, then SVG Fashions Private Limited versus Ritu Murli Manohar Lal Goyal. Okay. Again, friends, here there was a question of primarily on limitation. So let's understand that there was a question of limitation, because on limitation there have been a number of judgments, isn't it? So again, you see the Supreme Court noted that, look, as far as the balance sheet is concerned, this is to be considered as an acknowledgement of debt if there is an unqualified acceptance, admittance. So they say they have not discussed the applicability. NCLAT has not discussed that applicability of Section 88. So therefore they allowed this thing that, look, if it is admitted in balance sheet, then the limitation does not expire. It will be within time. I think we have already done this, so I'm not going into greater details. Amit Katyal versus Meera Ahuja. This is a judgment of 3rd March 2022. And here, okay. And this is also a very unique judgment. In fact, I would say that it cannot be quoted as a precedent. What happened in this case? Let's try to understand. It was a case of a real estate. The CRP was admitted. NCLAT also dismissed the appeal of the builder, the promoters. Now he went and filed an appeal, civil appeal before the Supreme Court. So while that civil appeal was pending, now please understand this. The home buyers which were very, small in number, around 80, 79 odd home buyers were there. They entered into a settlement with the promoter, right? They said that builder now undertakes to complete the project and hand over the possession. And also they said, I will refund around 3 crore 36 lakh, which was demanded by the home buyers. They said, sorry, I will do that. Okay. So the Supreme Court recorded that settlement, and then they said the home buyers can now withdraw the CRP proceeding. So, but what they did, see, please understand, they actually exercised power under Article 142 to permit the withdrawal of the CRP proceeding. So this judgment cannot be quoted as a precedent anywhere, because here extraordinary powers were used by the Supreme Court under Article 142. But anyhow, even in such cases, so therefore, what is the learning? Supposing in case of a real estate, the promoters should try to enter into settlement with the home buyers. Probably they can also approach the Supreme Court and say, under 142, please allow that withdrawal. So I think that can also be done. Okay. So this was what I wanted to mention. Okay. Then 17th February is Ruchi Soya Industries versus Union of India. Now this is, again, it was a custom authority which did not lodge the claim before the RP. So it's a similar case what we have done earlier. Here the Supreme Court says, now friends, please note down this judgment. This is important. Ruchi Soya. Now why I'm saying it is important? It will help you in countering rainbow judgment. Because in rainbow, the Supreme Court says the statutory authorities are not supposed to file the claim. And the RP should have considered the claim on the basis of the books of account. Well, that of course is on a different platform altogether, and I have made distinction on number of occasions on that. But here there is another judgment, Ruchi Soya, which was definitely earlier than rainbow. Now what does it say? Customs authorities did not lodge the claim. Now the issue before the Supreme Court is whether the claim of the respondent, which was admittedly not lodged before the RP, after issuing of the public notice, could be considered at this stage. So the Supreme Court says that a revenue authority which has not lodged the claim after the issuing of the public notice, right, before the approval of the resolution plan, the Supreme Court said that such claim which is not part of the resolution plan does not survive. Now look at this. This is quite contrary to rainbow, isn't it?
How it is contrary to rainbow, sir? Rainbow, it was filed before the resolution plan, no, sir?
No. That is, no, they did not. In fact, there is a dispute in the facts of the case also. Somewhere it is stated it is filed, somewhere it is stated it is not filed. So, and in any case, the Supreme Court also says that they were not supposed to file it. So that is why I'm saying it is contradictory. Supreme Court, in its terms, it says statutory authorities are not supposed to file the claim. The RP should consider it on basis of the books of account. So here there is a judgment which says you did not file before the approval of the resolution plan. So therefore, your claim does not survive, and they have referred to Ghanshyam Mishra and other judgments also. So all I'm saying is that, look, there are different kinds of judgment are there. And in fact, they have quoted, on the date on which the resolution plan was approved by the learned NCLT, all claims stood frozen, and no claim which is not part of the resolution plan would survive. This is our understanding from Ghanshyam Mishra and other judgments which are there. So this has been upheld again, once again. Okay. Okay. So now here it is, Consolidated Construction Consortium versus Hydro Energy Solutions Private Limited, 4th February 2022. Now here, a very small question. So I do not want to go into the facts of the case and other, because the time is also now running out. Because I need to complete all. So here, my dear friends, what is the case? The case is that we all understand who comes under the definition of operational creditor, right? A person who renders services, supplies goods, supplies, an employee, and the government dues. So 4 categories are considered under operational creditors. Now, supposing I have to get a machinery from the company, right? And I pay an advance to the corporate debtor that please make my machinery and then supply it to me. Now, on the contrary, corporate debtor is rendering services to me. I'm not rendering services to that, but I have paid an advance. Now, will that advance partake the character of a operational creditor or not? Now, NCLAT held that a purchaser, like I have to buy from corporate debtor, I will not come under the definition of the operational creditor because I did not supply any goods or services to the corporate debtor. So this was what was decided by NCLAT. Now the matter is before the Supreme Court that a person who gives an advance, right, whether that person will be considered as an operational creditor or not. So Supreme Court, what it says, what it said, what it held was, held is that, look, they say all advances will not be considered. But please consider the definition of section 520 and 521. Now 520 and 521 make a very, very interesting reading. So let's look at that first, right? Now, if we look at those two definitions, particularly the definition of 521, this says operational debt means a claim. And the next sentence is very important, friends. Underline that. In respect of the provision of goods or services. So they say that, look, it does not matter whether the goods or services are to be supplied by the corporate debtor or to the corporate debtor, but the amount must be in relation to the services. So therefore, the Supreme Court says that a person who has given an advance will also, because he was entitled to, would be included, right? So they say the NCLAT came out with a very narrow interpretation. And they redefined the 521. They say in relation to, the words are extremely important. So if you are giving this thing, so then it would be considered. So here it says, this leaves no doubt that a debt which arises out of advance payment made to the corporate debtor for supply of goods or services would be considered as an operational debt. So again, it is kind of out of box thinking. So friends, please note, if you have given an advance to the CD for supply of some goods or services, you can still be considered as an operational creditor. Okay. So this is the judgment.
Sir, it is not a happier note, sir.
Why? Because
if the advances are treated at the financial creditor level, then it makes any sense. Operational creditor level, what is the use, sir?
No. It's not financial credit. See, they say, please understand, I'm not saying all advances will be considered. Any advance which you are given to the corporate debtor for supply of goods or services. Now, it must be linked with that. Supposing you have given as a security deposit. Now, then you don't fall under, operational creditor.
So thereafter, we have to educate all our clients, corporate debtors now, that, you don't pay any money to anybody as an advance.
Without interest.
We need to tell them, redefine it. You give us as a security deposit and take it back and settle the amount for the goods.
Obviously, sir, because of the jurisprudence, many things change. So definitely those things are going to change that. Okay. Now, this is another judgment. This is a longer judgment. I'm just leaving it for a moment because this is a longer judgment. In the meantime, I think Devarajan Raman versus Bank of India. Yeah, this is a judgment where Anjali ma'am actually appeared before the Supreme Court. I think I will leave it to her to explain what are the facts of the case and what happened at the Supreme Court. Yes, Anjali ma'am, can you open your mic and video and please explain it to us if you are hearing me?
Yes.
Yeah, please go ahead.
Actually, what had happened, I'll just explain very briefly and then we'll go with your presentation, sir. So what had happened was that Devarajan Raman, his financial bid, I mean, he was appointed as RP by the Bank of India with respect to a certain CD, and his bid was accepted. Now, what happened was that the order of admission was set aside in appeal by the NCLAT, and he actually had to litigate for the payment of his fee Basically, the NCLAT, when it set aside the order of admission, they said you go back to the NCLT for your fee. So when he went back to the NCLT, what he claimed was strictly on account of the bid that had been accepted. But the NCLT, without any reasoning, and this is something that we've noticed in a lot of NCLT orders particularly, they just reduced the amount that he had claimed, even though he had claimed it in accordance with the bid that was accepted. So this Mr. Devarajan Raman, who is a very senior RP, he was handling it himself. So then for him, I filed an appeal before the NCLAT. But that was dismissed on the first date itself. And what the NCLAT said was, no, he only worked for a 3-month period and this much, whatever is paid to him is reasonable. So they went into the reasonability, what they considered as reasonable, even though one, Bank of India had agreed to pay the dues, and secondly, after the admission order was set aside, after the NCLAT had told him go back to the NCLT, he had, by way of abundant caution, written to the Bank of India and said, see, this is what I've computed. This is what I've computed. Is this correct? Bank of India had said, yes, this is correct. Despite that, NCLT reduced his fee and NCLAT did not consider this aspect at all. And again, theirs was also, their order was a little more, I would say, a little more elaborate than the NCLT's order, but again, very deficient reasoning.
Right.
So then we went to the Supreme Court, and before the Supreme Court, of course, the first hurdle that we met was the Supreme Court judgment, which was rendered by Justice Chandrachud himself. We were before his bench in Alok Kaushik versus, I think, Bhubaneswari. I'll give the, Mr. Ashish Makhija, sir, will be having the name of the judgment. So you see, he had said in that judgment that the NCLT can consider these aspects under 60 subsection 5. But in that case, the NCLT, why he had held this was, that case, the Alok Kaushik case was a case where an approved valuer had litigated for his dues, and there the NCLT had refused to enter into the question. They had said, no, now we've been rendered functus officio. So in this scenario, he had gone to the NCLAT, he had gone to the Supreme Court. Supreme Court had said, no, NCLT can consider these questions. And it had also looked at Regulation 34, which we, of the CIRP regulations, which we also pressed into service. So here we had to distinguish. What we told the Supreme Court was that that was a different case. This is an entirely different case. Again, we went through the facts of that case. We went through the facts of our case, and we also showed the two orders, the NCLT order and the NCLAT order, which were very much, which were pretty, I would say, devoid of reasoning. At least the AA order was very devoid of reasoning, and the aspect that the Bank of India had agreed. They had said, yes, your computation is correct. This was not taken into account by either the NCLT or the NCLAT. So what the Supreme Court did was, the Supreme Court went through everything. I mean, I was able to distinguish the Alok Kaushik judgment successfully, and the Supreme Court went through everything. And basically, I think the Supreme Court was very distressed at the fact that the reasoning was very deficient. They said, what is this? So they referred it, they remanded it back to the NCLT. One, they said a lot about the deficient reasoning. They said, how can you do that? Reasoning is the lifeblood of a judgment. And they remanded it back. They said, you go back to the NCLT, and they had said enough in the judgment about the fact that the Bank of India had agreed. They said, just go back to the NCLT. The NCLT has, of course, now they have agreed to the fee that Mr. Devarajan Raman had in the first instance asked for.
Okay.
So that is what happened.
Madam, sorry to ask this question. Did he get his cost also covered? Because it's
You see,
quite
whatever-
vexatious for him.
Yes, but he did not. See, actually, he did not ask for costs, and neither did we press for costs. See, before the Supreme Court, the Supreme Court is not the Supreme Court, the apex court will not go into the question of computation of fee. So whereas they saw everything, they agreed with us that the reasoning was deficient. And they also saw that the Bank of India had agreed. They said, no, you need to go back there. So basically, we were very happy with the fact that a judgment had been rendered by the Supreme Court, in which the Supreme Court had said, at least give some reasoning. Apart from anything else, the fact that a judgment had been rendered, in which the fact that sometimes judgments are given by adjudicating authorities, which are too, very, very basic and very limited and not and devoid of reasoning. This aspect was noticed by the Supreme Court.
Madam,
So we were happy about that.
Madam, thankfully, only that much is covered. In one
Yes.
of the cases, I have been also one of the victims. The judge was being very unreasonable in even talking to us.
Yeah.
Very unreasonable. And they are very harsh even without going into the facts. They are being harsh with us. And even though NCLT is appointed, when the financial creditor comes up for the change, they are not going into the facts of the case. They are not allowing us to speak even. And if they allow us to talk, even they would not consider the replacement of the RP itself. They are not giving that, and they are being very harsh to most of the time the RPs when we go to the NCLT, madam. Very distressing.
So that's why Mr. Raman said, I will fight it till the end. He's, that is what had distressed him. So he said, I will fight it till the end.
Hats off to him.
Yes, indeed.
I think it has been a great order. And in fact, as ma'am has mentioned, if we look at this, this is on your screen. In fact, very harsh pictures have been passed against this, because what it says both the orders suffer from an abdication in the exercise of jurisdiction.
Right.
I think the order cannot be harsher than this.
Yes.
And they say, in the absence of any reason.
Will we remove those judges, then we will only suffer. We will go for our bodies should go for request for replacement of those judges, and we will not have judges. Most of the benches are operating with one judge, and that nothing happens during the day.
That is, of course, another story. But at the end of the day, these orders definitely help us because ultimately it reminds NCLTs and NCLATs that, look, you cannot abdicate your duties. So therefore, you must give reasons. I think this has been a fantastic judgment, which is quite helpful to you see the RPs in future, particularly in respect of the fees, which has already been decided. And now, assuming that fees is not decided, supposing here there was a case where there was a bid and the Indian bank had accepted it. Now, assuming nothing happens, sometimes the NCLT appoints you, right, on from the panel. Now, in that case, now we can take a plea that, look, IBBI has given a minimum fees which is to be charged. So which is on the basis of the quantum. So I think even that now has to be considered as a very, very reasonable, because we have seen in our experience NCLTs and NCLATs, they have been very stingy about the fees of the RPs. Now, generally, they compare the fees with their own remuneration. Oh, we are not getting this much. You are charging so much of amount. Well, at the end of the day, that's not the good criteria, but I think this judgment really helps us. So thank you, Anjali ma'am, for explaining this in detail, because coming from the horse's mouth is always better, because I could explain whatever I could read, but I think you have given more insights to this particular judgment. Okay. So
Thank
friends, before I move forward, let me see. Yeah, this is the last one only. So I just left one judgment because this was a little longish, and I thought I will ask Anjali ma'am to speak first, because we are already on the verge now. So if you bear with me for next 5 to 10 minutes, I think I can deal with this. Otherwise, if you want me to
No,
close,
please go ahead, sir. We'll all be there. Whoever is available, let us listen to you.
Right.
We are
Okay.
gifted to be with you.
Okay. So this is a very interesting judgment, friends. Bank of Baroda versus MBL Infrastructure. Now, 18th January 2022. Now, in fact, this judgment actually did not help us in one of the cases also. But I tried to make a distinction. And I made that argument before the NCLAT And can you believe, I concluded the arguments in October, and till now the judgment has not come. The order was reserved and NCLAT is still looking at it. And I made a distinction to this judgment. Let's try to understand. I think I don't need to show you the on the screen. I'll just explain it to you otherwise. What this judgment is all about. Friends, look at 29AH. Now that's the interesting part. So if you have the books before you, friends, just open 29A and clause number H. Now that's a very interesting provision, right? So what does it say? A person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person. Now let's go to H straight away. Has executed a guarantee in favor of a creditor in respect of a corporate debtor against which an application for insolvency resolution made by such creditor has been admitted, and such guarantee has been invoked by the creditor and remains unpaid in full or in part. Now, what is the meaning? The meaning is that, look, if I am given a guarantee for securing the debts of a corporate debtor, and if that guarantee has been invoked and the CIRP has been admitted, then I am ineligible to file a resolution plan. Right? So this talks about that I may not have any other connection with the company, but I am a personal guarantor and I have given a guarantee invoked. Now here, an interesting situation came before the Supreme Court. Look at the situation. The director, say A, he gave a guarantee to, say, State Bank of India for the debts of the corporate debtor, say X Limited. So here there are three parties: A, personal guarantor, State Bank of India, and X Limited is the CD. Now an operational creditor starts the CIRP, right? Now the question which arises is, please read 29AH carefully and please tell me whether A is entitled to file a resolution plan or not. Look at it carefully. And
it should remain, it should be invoked and remain unpaid, full or in part.
No, sir. Just I'm emphasizing on the word such creditor, which is coming in the third sentence. Please read it carefully once again. Has executed a guarantee in favor of a creditor. So I have executed in favor of SBI in respect of a corporate debtor, which is X Limited, against which the application for insolvency resolution made by such creditor. Such creditor means SBI should start the CIRP.
Need not be the case, no, sir. Even operational creditor would have started, no, sir.
That's, but read the language of the section, sir. This was the interpretation saying that, look, the CIRP was started by an operational creditor and not by SBI. So therefore, I'm not disqualified. I will be disqualified if SBI starts. Now that is the whole situation, isn't it? Very interesting. I mean, only a one small sentence by such creditor makes the whole difference, isn't it? So the matter went to the Supreme Court, right? Justice Sanjay Kishan Kaul was heading the bench. Now what he says, as our friend Mr. Narayanan is saying, he says, look, it does not matter who starts, whether it is started by, in fact, you see, there the question is not of the operational creditor. In fact, it was started by another financial creditor, right? Instead of SBI, say Indian Bank had started. So he says, whether one financial creditor starts or another financial creditor starts, this is equally applicable. So such creditor should be termed as any financial creditor. So now they have interpreted such creditor as any financial creditor. Now, here comes another interesting part. Now, how I made a distinction, I don't know whether that is good or bad, but I made it, right? Because as lawyers, we have to find out some loopholes. My case was that it was started by operational creditor. So I argued before the NCLAT that, look, my lords, this judgment does not apply because the words which have been used by the Honorable Supreme Court are started by any other financial creditor. So here, in my case, it is operational creditor. So therefore, this 29AH does not apply.
No, sir. Any creditor means it can be interpreted as any creditor. No, so need not be operational or financial. No,
I know, my dear friend, but
you are utilizing it.
I had to argue for my client, so I made a distinction. I don't know whether that distinction will be accepted
So
by
if
the.
I were against you, I would have fought the case and I said, for any creditor, I would have gone for interpretation to Supreme Court.
I don't deny.
I would have used Adili Sharma to fight my case because she has won one case.
Now you are pitting Anjali ji against me. Okay, now let us look at another situation. What happened in this judgment? Now, after this, giving this interpretation of 29AH, now the Supreme Court also noticed one more thing. They said, look, much water has flown. The plan has been approved. See, eligibility has to be considered when the plan is being approved. But if the plan has been approved, it has been implemented also. And there are 23,000 employees which are working in a company. They say it will be unfair to unsettle the situation or disapprove the resolution plan. So we are invoking Brahmastra. And what is Brahmastra? Article 142. So they invoked 142, Article 142, and they said, sorry, we are not revoking the resolution plan. So as it is, what has been approved, it is approved. So now in my case, I also mentioned that, look, my lords, this was done, so you should also do that. But anyway, NCLAT does not have 142. So anyway, let's see what is the fate of my case. But this was a very interesting, again, interpretation of 29AH. Okay. So I hope, friends, Rainbow I have not covered. I think it has been substantially covered. Otherwise, what I'll do is I've got a separate presentation I'll share with each one of you, right? You can go through that presentation.
Please, sir.
And along with that, I'm sharing this presentation, which I shared, and also a whole bunch of judgments running into 1100 pages, a PDF format, okay? Where all judgments of 2022 you will find at one place. You don't have to go anywhere. So thank you, friends, for hearing me patiently. I hope I was able to convey something. I mean, I was able to transmit something, some knowledge from my side to your side.
Very good session.
The major
Very
gainer
good
is,
session.
the major gainer is paid, who has been sincerely attending, unlike any other session. The most of the time that, the sessions are begun and ended only by the team. I'm really amazed with the peer listening completely to this. Thank you. So you should forward all those, with all compliments, you should forward SAR's presentation to us.
Sure. And I've mentioned my phone number on my chat box, on the chat box. I'm also mentioning my email ID also. Of course, that is there in the presentation also, but you can also note it down. So over to Peer now. I think I'm over. So I'll hand over the proceedings to Peer now.
So I would like to extend my thanks and gratitude to Ashish Makhija. Thank you so very much, sir, for such an interactive, informative, and educative session. We are very grateful for that. Share this and share your views and experiences on this topic. Members, I must say we all have learned a lot from this session, and we look forward for your support and association with us in our future program also. Thank you once again for your contribution. And at the end, I would also like to thank all our participants for attending this series. Tomorrow, we will be having another important, interesting topic, which will be on analyzing the current issues in liquidation process and future reforms. So hope this series is beneficial and provide useful information for our members. Thank you all. Have a great evening.
Thank you. Thank you. Thank you, Peer. Thank you. Pleasure.
Thank you, sir. Thank you, madam.
Thank you, everyone. Thank you, sir.